for delivery of order, item 1, AD 3394 of 23.
For reasons mentioned in the order, the interim anticipatory bail granted to the petitioner is hereby made absolute with practical.
Prayer for adjournment, if any.
May I please? Item 32, your lordship.
Item
32.
no, Kim, let him. Yes, item number 32.
32.
Yes,
Neither the CD nor the information regarding filing of charge sheet is available. Your lord.
is there not today? Mr. N. Pathak, the counsel for the petitioner, also heard Mr. R.J. Papa and the petitioner for. I'm sorry, Lordship. We have just received the information now. Charge is submitted.
Charge is submitted. Oh, just now.
You are on interim bail.
Yeah, I'm an interim.
Then let it be called for. You have appeared before the.
Yes, before the police station, I have appeared. But I didn't get any summon.
No, we'll pass order when the matter is called.
Yes, there is an interim, your lord, pass the order. So I said appear there.
Where? You have already appeared on.
No, because I didn't get any summon.
No, this is not a question of the.
Yeah, yes, I have appeared before the police. I have appeared.
Okay, we will pass orders when the matter is called. When item number 42 is called, we will pass.
But I have some problem, your lordship. I have to leave this court early, your lordship, today.
We will show your attendance
Yes.
and I will pass.
Yes.
After going through the record. Okay.
All right. Oblige.
Please.
Yes.
Madam, I mentioned item 7 in this regard. In this case, we have filed an additional affidavit containing the name of the informant, so that may be called for lot.
May I please, Lord? My lord, I wish to mention for listing of two bail application out of the same FIR, my lord. One of the petitioner will appear on examination on 5th December. Kindly take this matter on 4th December, Monday. Highly.
May I please, sir? My lord, pursuant to the NPWA, my lord, I surrendered before the court on 21/8, my lord. Until then, my lord, I have been in custody, my lord. Kindly matter may be listed for today, my lord. Today, my lord.
Today we are it is not listed as an unlisted item.
Yes, my lord, not unlisted.
Unlisted it may be difficult because we are sitting late. So let it be on Monday. On Monday.
And my lord, it may be on Tuesday.
Okay.
May it please, your lordship. I beg to mention my item number 57 of the supply list, ma'am. In that matter, my lord, probably my lord, charge has been submitted. And petitioner was an interim, my lord. He appeared before the IO and he has cooperated with the investigation.
Heard Mr. S. the counsel for the petitioner. Also heard Mr. R.J. Prabhu, the petitioner public prosecutor, who submits that though the case diary was called for, however, in the meanwhile, charge sheet has been late. Bearing charge sheet number 295 2026, dated 31/10/2000. Counsel for the petitioner has submitted that the petitioner was allowed to go on interim anticipatory bail by order dated 27/9/2023, and in pursuant to the directions of this court, he has appeared before the investigating officer and has cooperated in investigation. Stop. In view of the laying of charge sheet and in view of the submissions made by learned counsel for the petitioner, the interim anticipatory bail granted to the petitioner Muzahidul Islam by order dated 27/9/23 is thereby made absolute, with condition number 2 attached to the said. Condition number 1 and 2 attached to the said order remaining intact.
Highly obliged, sir.
May it please your lordship. Lordship, I beg to mention item number 9 and 10, lordship. Lordship, my senior some difficulties to conduct a case today.
What is your name?
9 and 10, D. Roy, lordship.
On request, on submission of Mr. D. Roy, learned counsel for the petitioner, that his senior, who is the conducting counsel in this case, has personal difficulty and prayer for adjournment is made. Considering the ground, the prayer is allowed. Let
Matter
this
may be
matter be-
fixed on lordship, 6th or 7th, lordship.
Let this matter be listed after a week.
Kindly date will be fixed.
Date registry will decide, otherwise it will be difficult from here to manage.
Obliged.
With due consent of the other side, I beg to mention item number 52, lordship. I beg for adjournment today, lordship. Matter may be listed after vacation.
Heard,
52, lord.
heard Mr.
M.R. Chaudhary for the petitioner.
M.R. Chaudhary, learned counsel for the petitioner, who prays for an adjournment. He has submitted that he has informed the learned counsel for the respondent who does not have any opposition to the prayer for adjournment. Considering the submission made by learned counsel, the prayer is allowed. Let this matter be listed after court.
Obliged, lord.
May I please your lordship, make to mention item number 3 and 8, my lord. Item 3 and 8, any matter may be adjourned 40 days.
Heard Miss L. Islam, learned counsel for the petitioner, who prays for an adjournment. Prayer is allowed. Let this matter be listed after it.
One more prayer, lordship, that is item number 41. No interim, no CD, lordship. I think it's prayer there for 40.
Heard Miss L. Islam, learned counsel for the court, Mr. R.J. Barua, learned additional public prosecutor, who prays for another date for producing the case. I prayer is allowed. Let this case be listed again on 8/12 for case day. You are on interim.
No.
Okay.
Agree.
My lord, I beg to mention item number 51 of the main list. I'm appearing on behalf of respondent advocate R. Das, who is out of station. In the last order, this case was fixed on 9 January. So accordingly,
Today it is wrongly listed.
actually it was on or last date order was mentioned 9 January.
You have informed the
I
petitioner,
informed the other side, they have nothing.
learned Mr. R. Mr.
I'm appearing on his behalf.
What is your name?
I'm S. Kolita.
Heard Mr. S. Kolita, learned counsel for the respondent,
51.
who submits that this case was wrong. This case has been wrongly listed today. As per the last order, this case ought to have been listed on 9th of January. Hence, he prays for an adjournment today. It is also submitted that the counsel for the petitioner has been informed by that and who does not have any objection. Considering the submissions made by the counsel, the prayer is allowed. Let this matter be listed on 9th of January.
May I please, your lord? Lordship, I beg to mention item number 35, lordship. Lordship, today some difficulty, lordship. Taking this matter, lord.
Heard Mr.
HP Nepal.
H.P. Nepal, and counsel for the petitioner, who prays for an adjournment on the ground of personal difficulty. The prayer is allowed.
Interim is there, lordship.
So we have received the case that is okay.
On the other hand, before the prayer, on the other hand, an additional prosecutor submits that case diary has arrived. However, considering the grounds mentioned by the learned counsel, the prayer is allowed. Let this matter be listed again on 8th of
We retain the city road.
8th of December. The case diary may be retained till next date. The interim order shall continue to
Obliged.
May I please, Lord, prayer for adjournment of item number 62 from supply list on behalf of petitioner.
62.
It may fix on next week.
Heard Ms.
T. Sharma.
P. Sharma, learned counsel for petitioner, who prays for an adjournment. on the ground of
Personal
personal
difficulty.
difficulty, considering the ground the prayer is allowed. Let this matter be listed after
1 week.
after
I beg to mention item number 43. The file submission period is not available. 43.
Well, is that received, Lordship?
it is available.
Colleague is on-
No, when the matter will be called, it will be not called now.
Itiyan amatan na, ito tayo mati.
It is your lordship. Your lordship, the adjourn the matter.
Which matter?
Item number 40.
Item number
40.
What is it?
third Miss
DB go.
DD
DB go.
DB Gogoi
Go ahead.
Gohai. You are for petitioner or
Petitioner.
learned counsel for the appellant slash applicant who prays for an adjournment on the ground of
Personal difficulty.
difficulty. Considering the ground the prayer is allowed, that matter be listed after 2 weeks.
Hi.
May I please your lordship? I'm beg to mention item number 40 of today's daily date. As my senior will not be available on
Third
today.
Miss, what is your name?
Upasna Sharma.
Third Miss U Sharma who prays for an adjournment on the ground of unavailability of her senior who is the conducting counsel in this case. On the other hand, it is there.
It is received.
On the other hand, an petition for the prosecutor submitted is very, which was called for as the right. However, considering the submission made by the prosecutor, there is a let this matter be listed again on 12th of December. You are on interim.
Yes.
The interim order, if any,
Yeah.
shall continue.
May I please, your lordship? The document on item number 39, lordship. May I adjourn this matter for a week?
Is that received?
You are on interim.
Yes, lordship.
Then for a week may be difficult. Then it will be as per the convenience of the
Lordship.
39. 14, 12.
third Mr. What is your name?
Is it a
Third Mr. P.J. Rattal, counsel for who prays for an adjournment on the ground of unavailability of the conducting senior counsel. Also heard Mr. R.J. Purva, who submits that the case diary has arrived in the court. However, considering the submissions made by learned counsel for the petition and prepare for adjournment, let this case be listed on 14
12.
14/12/3. Interim order shall continue.
May I beg to mention for updation of item number 51, lordship,
Today, the update.
regarding the custody of juvenile, lordship.
51 already adjourned. Lordship.
61.
61.
The custody of juvenile more than 18 days, 80 days, lordship, is in home, lordship. Last occasional, lordship, has
Some instruction was called for.
called for.
Whether it has, if it has arrived, we will take it up at 2.
My lord, may I please your lord? But I have for correction of order, lordship, but may I pay for 2 day authority before rising?
Correction of bail order, some
Yes.
mistake is there.
Yes, sir.
Okay.
It is inside method to project.
For withdrawal, item 53 of the supplementary.
Third Mr. You are withdrawing.
It happened.
Third Mr. What is the reason? Bail application.
Bail application.
Third Mr. K. Thakur, learned counsel for the petitioner who prays for allowing the petitioner to withdraw the instant bail. The prayer is allowed. This case is dismissed on withdrawal.
Appearing on behalf of D. Mason may be referred.
K. Thakur with appearing on behalf of Mr. D.
Delay list for motion item
May I please, your lordship, the bail application, my lord. FIR is the page number 17, my lord, triangular, my lord.
What is the offense?
My lord, under section 326 and 307, my lord. The allegation is that, my lord. May I read the FIR, my lord?
326 is the, whether case diary would be required. Since when you are,
326 and 307, Lord. An allegation is that, my lord, he attacked him with one of the dao in the neck.
My lord,
case diary would be,
my lord, I want to just point out one thing, my lord. The incident was occurred at 9:30 p.m. my lord, and in the village area, my lord. And the as per the my lord informants, my lord, the attacker has my lord,
no,
attacked on
if
the
you are submitting on fact,
my lord.
unless you peruse the case diary,
Yes, my lord, that
we
is correct,
cannot
sir.
verify.
There is a 43 days today, my lord. He is in custody, my lord.
We will give third Mr.
As well, sir.
S. Ajurika, Learned Counsel for the petition. Also heard Mr. R.K. Borwa, the petitioner for the petition. Considering the nature of allegations leveled against the petitioner in the FIR, perusal of the case diary would be necessary. Hence, call for the case diary. Fixing
11-12.
11-12 for the
I'm deeply obliged.
May I please, your lordship? My lord, item number 40 was mentioned, my lord, but that was wrongly stated that, my lord, we are on interim. Diary is there. My junior, my lord, he wrongly stated that we are on interim.
14 in item number 14.
40, my lord.
Interim portion to 30.
Can it be, my lord, on an earlier date, because as diary is there, case
Can
diary
be-
is available,
It is
my lord,
on
because,
your request, it was adjourned.
my lord, second half, I will not be available. That is why.
Okay.
Can
When
it
do
be
you want it?
on Tuesday, my lord, if I'm obliged, lordship.
Item 54,
May it please your lordship. My lord, the petitioner before your lordship is a stockbroker at Delhi. My lord, he came to attend his brother's wedding in Guwahati along with his wife and a minor child. And after attending one of the marriage function, and person was with his vehicle was standing near the marriage venue. Then they had some altercation. Both sides, the other side slapped this petitioner. Then he, along with the other two friends, and both parties entered into a fist cup. And later on, my lord, they didn't knew that the person whom they had this altercation and fight. He is a deputy commissioner, one of the district and a top bureaucrat of the Assam civil service. And my lord, both the parties, my lord, from the ladies' side also, from marriage side, the ladies went to have a compromise and all. But he was adamant, and my lord, your lordship will find from the FIR that the case has been registered under 325, 307, and even 392. Your lordship will see for the date, NHS 6 at page 28. Tomorrow is the reception, and my lord, because those dates will be relevant, my lord. Annexure 6 at page 28, my lord, your lordship will see. This is my brother's invitation. 27, the night the occurrence took place. Then he missed the marriage that was on 28, and the reception is tomorrow, my lord. And your lordship will see the first the FIR lodged against this person, my lord, that your lordship will find at page 13 is that 15 is the type copy, my lord. I am not praying on the behalf of the other two of the friends, but only if I'm seeking today an interim bill for this person, my lord, till the time when case diary come, my lord.
No, only one petitioner is before this.
Yes, my lord. I'm not coming for because only my brother's marriage is there. So I do not want to trouble your lordship, my lord. So, and there are cross-FIRs. Our case also registered because he is a police, he is a bureaucrat, my lord. That's why his case is 310, ours is 311, my lord. And the ladies from the marriage side also went to request him that we are all neighbors, let us settle this matter amicably. And your lordship will find that he has even mentioned that I have taken 20,000, whereas in my pocket there was 45,000. Since he has said that the police, he told the police that 20,000 has been seized, That's why from out of the 45,000, the police has also kept 20,000, gave me a seizure list and returned the 25 to the other family members. The first FIR is at page 15 and our cross-FIR is at page.
No, but the question is the allegation. Yes, Mr. Guru.
I am only praying because of the marriage reception and interim bill till the next date, my lord. Your lordship will keep an early date on the next week, my lord. Let me attend my brother's wedding tomorrow, my lord. Your lordship has considered only when there are medical emergency or when a person is sick, date, sometimes.
What was the injury caused to the?
Simple, my lord. They were all sitting there. I have asked, specifically asked that. He was sitting in the police station, talking to them, trying to influence. And even initially, police did not want to accept our FIR. But as we said that just because he is your lordship will see the contents of our FIR. Our FIR also registered against it. Only, my lord, your lordship may fix it Tuesday next. I don't have, but till only to attend my brother's wedding tomorrow, my lord. I'll be present in the court on Tuesday. If your lordship finds any material in the case diary to here, your lordship will direct me to immediately go and surrender before the seizure. It was he has completely misused the process of law by getting it registered, all this non-bailable section. Our cases, they have registered it under bailable section. His driver was there, security was there. Yes, there was an altercation and he first slapped. He was there. We have stated in our FIR that he first, the wife has stated that he first slapped the husband.
Who is Mrinal Bora?
He is the, my lord, ACS officer of the 2015 batch.
He has written the FIR himself after the incident.
Yes. My lord, both parties are known. They were sitting in the police station requesting him that tomorrow is the marriage. Please don't do it.
Yes, Mr.
So that, my lord, otherwise, my lord, the case of 307, my lord, registered, my lord. Otherwise, my lord, since his brother's marriage is there, that part I leave it to your lord, my lord. So, hypothetically, my lord, call for a case there only now.
And that's why we have not come for the other friends also. We are not troubling your lordship with the other friends, my lord.
Where is your FIR?
My lord, my FIR is at page 22. My wife has lost, my lord. I have a small child also, my lord. I have the honor to page 22, my lord. I have the honor to state that before you today morning at about 2:30 a.m. when we returned from the marriage, my lord, on incident occurred near the residence of my matrimonial home at Byland number 3, Torun Nagar, ABC, while one resident of Sri Baddirai complex, namely Sri Minal Bora, got involved in a fight with my husband, Sri Lukesh Roy, and some other person. The incident started when Sri Minal Bora, under influence of alcohol, reached the entrance of his residence by driving his vehicle in a rash and negligent manner. At that time, my husband, along with some of his friends, were busy in receiving some of the requisite articles which were supposed to be delivered late night for the purpose of organizing the marriage ceremony of my brother-in-law, which is scheduled by tomorrow. While my husband and his friends were standing outside the entrance gate of the Baddirai complex, accused Minal Bora reached the place of occurrence driving his vehicle in a rash and negligent manner under the influence of alcohol. Upon encountering my husband, he engaged in inappropriate and aggressive behavior, leading to a heated argument. The situation escalated when the accused physically assaulted my husband by slapping him. Out of such sudden provocation on the part of the accused, my husband and his friends also lost their control over the situation and involved in the fight. And ultimately, when the accused threatened to shoot them, they ran away from the place of occurrence. And at the time, accused, who was under the influence of alcohol, accidentally fell down on the road, for which he sustained some injury. After the incident, when my husband reached home, he narrated the entire incident to me and our family members, and he decided to lodge an FIR of the incident in the morning. However, the accused person misusing his position and for being a
but mainly for your to attend your brother.
Yes, man. Only, but that's why we are not troubling your lawsuit with the other accused person. We'll file it later on. When the case diary comes, your lawsuit will call for the case diary of both the cases, man.
Then you have to surrender again after the attending marriage.
Your lawsuit will fix it on next Tuesday. After your lawsuit looks into the case diary, if your lawsuit thinks that my further custodial detention is required, then your lawsuit will order it, my lord. Because they are all people belonging to the rest.
Now we don't know the other side of
this. Your lawsuit will, instead of putting him behind bars, your lawsuit will fix it on Tuesday or Wednesday, next local police station, both the case diary. After that, if your lawsuit finds that my further custodial detention is required, your lawsuit will direct me to surrender. I'll surrender. That undertaking, I give it to them.
No, not on that.
But, yeah.
You either we have to peruse the case diary.
Yes, ma'am.
And then consider the matter.
Yes, ma'am.
Considering your special consideration of
yes, ma'am.
Special plea of marriage.
Yes, ma'am.
You may be allowed to attend the marriage.
Yes, ma'am.
but with a with a condition that after attending marriage, you have to surrender on the next day. Now you are behind the bar.
Yes, ma'am. Your lordship will fix it on day, after again, one coming out, these people are not
Then you have to remain,
putting
because now we don't know
madam,
the anything.
let's say,
What is the injury?
yes, ma'am. After your lordship looks into the case diary, if your lordship finds that there are materials to substantiate the allegations made, your lordship will direct me to surrender. I will surrender during that course of the day when your lordship rejects it, if your lordship finds material. That undertaking your lordship may record. Instead of the ones coming out against his small child is there, wife is there, brother is a HDFC employee, sister-in-law, all belong to respectable families. They will not abscond.
Where is the statement that your brother is getting married?
Yes, ma'am. That marriage I have given the invitation card, madam. Your lordship.
No,
Or
in
statement.
the bail petition.
Yes, ma'am. Just a moment.
There is a cross.
page 8 lot.
Page 8, sorry. Last line, ma'am. And I have given the wedding card.
Mr. P.D. Kuan, learned senior counsel assisted by Ms.
Valentina Belabeno,
Ms. B.
PV Thani.
B. Here. Also heard Mr. R.J. Purva, learned additional prosecutor. This application under section 439. When were you arrested?
My lord, on 27/11/2023.
This application under section 439 of the Code of Criminal Procedure, 1973, has been filed by the petitioner, namely Lokesh Ray, who is detained behind the bar since 27/11/2023 in connection with Bhangagar PS case number 310/2023 under section 341/325/307/392 of the Indian Penal Code. The list of accusation against the present petitioner is that on, where is the FIR?
Page 15, man.
On 27 on 27/11/2023, one Mrinal Bora had lodged an FIR before the officer in charge of Bhangagar Police Station, inter alia, alleging that on that day, when the first informant was returning after attending a marriage ceremony at Hatigao at about 2 a.m. at near ABC Tarun Nagar, he was ambushed by 4 miscreants who assaulted the four miscreants who assaulted the informant and caused grievous injuries on his person and also took away 20,000 from the first informant. The name of the four miscreants involved in the incident has been mentioned in the FIR, which includes the name of the present petition.
Counter-FIR is at page 22.
Learned count. Learned senior counsel for the petitioner has, what is your submission?
My lord, there's a Counter-FIR at page 22.
No,
making-
what has happened
My lord,
regarding the incident?
my lord, he first started he was the aggressor. He slapped this petitioner first.
Learned counsel for the petitioner has submitted, learned senior counsel for the petitioner has submitted that on the date of the alleged incident, there was an altercation between the petitioner and the first informant. Petitioner and some other persons and the first informant, in which it was the first informant who had initiated the
Slapped the
Altercation
petitioner
by
and was
slap-
in an
by
inebriated condition.
slapping who was in the inebriated condition? Mr. Kaur, who
Yes.
are,
The informant.
it is by slapping the present petitioner. It is also alleged by the learned, it is also submitted by the learned counsel for the petitioner that the first informant was at that time in an inebriated condition, and in this regard, an FIR has been lodged by the wife of the present petitioner on the state on 27/11/23. That is on the same day when the FIR was lodged against the present petitioner. What else your submission?
And he has not sustained any grievous injury because when this wife went at the police station onto his house, he was sitting there. And he was shouting before the document. Those things are not out of record. Your lordship will record that he has not sustained any grievous injuries because this
They
is they are also
cannot be recorded
Yes,
at
sir.
this because my lord,
Okay.
it's a case of 307.
Okay,
Let
okay,
the
my lord, that may not be
case that he
No.
announced.
okay. Let it leave, my lord, because there are so many incidents which have not been mentioned in the FIR by us.
No, I am only considering because of the marriage.
Yes, my lord. Yes, marriage, that card is, my lord, at page 28.
Learned counsel for the petitioner has also submitted that the
Marriage reception is on 22/12/2023.
brother of the marriage reception ceremony of the brother of the present petitioner is fixed tomorrow. That is on
2/12/2023.
2/12/2023. 2/12/2023, and he therefore prays for an interim bail in the event this court interim bail to allow the petitioner to attend the marriage reception ceremony of his brother, namely
Pankaj Roy. Mine.
what is namely Ayushman Mayank.
Yes.
Is he your brother?
Dr. Mr. Sahadev, just I'm checking. Brother, my lord, we have made a mention at paragraph number page 8. Page 8, my lord. Paragraph
When
number
when
9.
the case diary can be called for?
My lord, at the earliest lordship, we can fix it on my lord, 5th lordship. 5th of December.
One man. On the other hand, then an additional public prosecutor submits that considering the nature of allegations leveled in the FIR against the present petitioner, perusal of the case diary would be necessary. Hence, call for the case diary fixing
My lord, 5th of December. Lord.
5th of December for case diary. However, considering the fact that considering the submissions made by learned senior counsel for the petitioner, as well as considering the fact that a cross-FIR has been filed, as well as the brother of the marriage reception ceremony of the brother of the petitioner is fixed tomorrow. Able to attend the marriage reception ceremony of his brother, the petitioner is hereby allowed to go on interim bail of rupees 30,000 with one surety of like amount to the satisfaction of learned Chief Judicial Magistrate,
Kamrup Metro at Guwahati.
Kamrup Metro at Guwahati, with following conditions: that the petitioner shall appear before this court personally
On 5th.
when the next date of this case is fixed. The petitioner shall not, in the meanwhile, directly or indirectly make any inducement or let
And-
this
And will not leave the jurisdiction because he is Delhi, will not leave the jurisdiction of Kamrup Metro.
the petitioner shall not leave the jurisdiction of the Chief Judicial Magistrate. Who is the
Kamrup Metro, Chief Judicial
Chief
Magistrate.
Judicial Magistrate, Kamrup Metro till then.
I'm
Let,
deeply,
let this case be listed on 5th of.
deeply.
Candidates for motion, item 4.
May be
Yes.
Indian order lordship case 48. The order, this judgment has been passed lordship by the principal judge family court Kolkata lordship on 11/8/2022. Whereby directed the petitioner lordship to give maintenance amount of rupees 3,000 lordship to the opposite party or not.
Maintenance.
Maintenance.
Okay, we are issuing notice. How much?
Lordship 3,000 to the petitioner owner and 1,500 to the child owner, male side owner. In total owner 4,500.
Heard, Mr.
Yeah, okay. My name is not the public lordship. My senior name is dear lordship.
Heard,
DK.
Mr. F. Hawk, learned counsel for the petitioner. Also heard. No, heard Mr. F. Hawk, learned counsel for the petitioner. This application under section 397/401 of the Code of Criminal Procedure, 1973, has been filed by the petitioner, namely Safiqul Islam, impugning the order dated, impugning the judgment and order dated 11/8/2022, passed by learned Principal Judge Family Court, Barpeta, in FC within bracket criminal number 362/2021, whereby the petitioner was directed to pay a maintenance allowance of 3,000 per month to the first party, to the respondent, who is his wife, and rupees 1,500 per month to the minor son of the respondent. Issue notice to the respondent and call for the case record of FC criminal, FC within bracket criminal case number 362/2021 from the Court of Learned, Principal Judge, Family Court, Borpeta. The petitioner shall take steps for issuance of notice on the respondent by registered post with heading within 3 days from the date of this order, returnable after 4 weeks. Let this matter be listed up.
Apply.
Item 5,
May I plead the lordship?
Apply.
Five.
Yes.
482 application lordship for passing of FIR dated 27/3/2022 and the charge sheet dated 30/11/2022. Lordship will find the FIR in page number 14.
You have implemented the respondent. There was a direction.
Yes, sir.
And that was perhaps allowed by order dated 11/10.
Yes.
I allowed for impleading. Impleading whom?
Yes.
Whom?
For mandatory.
But whether they have, after allowing the IA, they have taken steps.
My lord, that, my lord. Because against this person, my lord, charge has been submitted under section 376 3, lordship. Because the victim girl is aged about 13 years.
No, on last occasion, there was an order
My lord,
that petitioner has not yet implemented the informant.
yes, that has to be. Check করা নেই এখন। বাকি করা নাই।
Allow it, sir.
Registry shall be- Yes, yes. it has- Okay. Okay. Now what is your thought?
Lordship, I am not the named accused in the FIR, Lordship. Lordship will find the FIR in page number 14.
But charge sheet has been laid
Yes,
against you.
at this stage also, I'll call to, I'll try to call for the scan copy, lord.
Can copy of the,
Scan copy of the my lord, LCR, lord. Along with the case diary and 164 settlement on the medical report. Because he is praying to my lord, was the FIR along with the search.
Miss, what is your name?
RR cycle.
Miss R.R. Learned Counsel for Petition. Also heard Mr. R.J. Burwa, for the petition for the prosecution. Considering the nature of prayer made in this petition under section 482 of the Code of Criminal Procedure for 1973. Perusal of the scanned copy of the PRC case number. What is the PRC case number? Case number is not mentioned.
Not mentioned, lord.
What is the GR case number?
Also, yes.
No, you have to mention.
Yes, lord, they have to
You
mention,
have
lord.
to, otherwise which record we will call for?
PRC number.
Because charge sheet is Charge sheet is there in the PRC case.
Yes, no, certificate of put it.
You find out
Yes,
You-
Lord.
or you take time.
Okay, Lordship, next step.
Express procedure.
On request of learned counsel for the petitioner, this case is adjourned for facilitating the learned counsel to see the connected PRC case number in this case, which she will inform to this court on the next date. Let this matter be listed again on Monday.
14.
Let this case be listed again on 14th.
In this matter, Lordship had called for the lower court records, the records which are there before the board. But these records are awaited, it has not come. Juvenile, his bail was rejected by the board. But the records are not here.
Then what is to be done? We have to wait for the court.
I have three counseling reports. The counseling reports are available in the petition, Lordship. Three counseling
No,
reports.
but on what was the rejection? Why it was not?
Lordship will see page number 24, rejection order.
Only at this stage. More than 80 days he is in home. In the midterm of this month, Lordship, his exam of class 7 will be held. Otherwise, 1 year will be lost.
No, we will ensure that your examination, you do not keep the exam.
And in fact, the rejection order was not according to section 12. Because section 12 of the JJ Act says that it can be rejected only on the ground that if there are chances that he'll mix up with other criminals, only then it should be rejected. But here it was rejected on the ground that allegations are grave, and then he needs more counseling. Lordship will see section 12 of the JJ Act. I'll read out the proviso slowly. I'll read out the section. When any person who is apparently a child and is alleged to have committed a bailable, non-bailable offence is apprehended or detained by the police or appears or brought before a board, such person shall, notwithstanding anything contained in CRPC or any other law for the time being in force, be released on bail with or without surety or placed under the supervision of a probation officer or under the care of any fit person, section 12 of the Act. Provided that such person, section 12 of the Act.
Yeah.
Proviso is important, provided that such person shall not be so released if there appears reasonable grounds for believing that the release is likely to bring that person into association with any known criminal or expose the said person to moral, physical, and psychological danger, or the person's release would defeat the ends of justice, and the board shall record the reasons for denying the bail and circumstances that led to such a decision.
Okay, so only for this reason he can be denied,
Here,
which is not stated in the order.
appealed.
So let
Some interim order can be granted till and let the records come.
okay. Mr. ABT Haq, learned counsel for petitioner. Also heard Ms. S. Jahan, learned editor for prosecutor. Appears from record that by order dated No, not, but by order dated 2012-2023, the case diary of Olympias case number 68/23, as well as scanned copy of the case record of Olympias case number 68/23 pending before the Juvenile Justice Court, Carely was called for correction with this case. However, same has not yet elected. On the other hand, the counsel for the petitioner has submitted that petitioner, being a juvenile, has been detained, has been kept in the where he has the observation home Jorhat has been kept in the observation home Jorhat since last 89 days, and he is a student of class 7, and his school examinations are due to are likely to be are going to be held in the month of this month itself. On the other hand, an additional public prosecutor has pointed out that while rejecting the prayer for bail of the present petitioner, the principal magistrate family court appears to have not complied with the provisions of the section 12 of the Juvenile Justice within bracket Care and Protection of Children bracket close Act 2015. He has pointed out that in the instant case, the prayer for bail was rejected by the principal magistrate Juvenile Justice Court on the ground that on the ground of serious nature of the offense involved in this case, as well as on the ground that further counseling for the better interest of the CCL is required, and releasing the juvenile at this stage may hamper the investigation. Whereas, as per the proviso to section 12 of the Juvenile Justice Care and Protection of Children Act 2015, a bail of the child in conflict in law may be rejected only if there appears to be reasonable apprehension for believing that his release is likely to bring the said juvenile into association of any known criminal or to expose said person to moral, physical or psychological danger, or the said release would defeat the ends of justice. However, no such observation has been made in the order while rejecting the bail of the juvenile. Let a reminder be issued for the scan copy of the case record of LMPS case number 68/20 from the Juvenile Justice Court Vishwanath Nagar. Fixing, give a long date, January.
February. February 7th or 12th of February.
Fixing 12th February for record. In the meanwhile, considering the submissions made by an additional public prosecutor, as well as considering the fact that prima facie it appears that the bail of the juvenile has been rejected in contravention of the statutory provisions of section 12 of the Juvenile Justice Code Act, Juvenile Justice Care and Protection of Children Act 2015, as well as considering the counseling progress report of the juvenile annexed along with the state criminal revision petition. The bill, in the meanwhile, the KJB is hereby directed to allow the petitioner within bracket juvenile and what is his name?
Babu Das. Neki, Babu Das is
Ripon
guardian.
Das.
Oh, guardian.
Ripon Das may be allowed to
Release from the observation home no? And keep it in custody of the legal guardian.
may be released on bail on such terms and conditions as deemed fit by state juvenile justice court, and during such period he may be kept in custody of no, this is not
So his legal guardian,
kept in custody of who is the legal guardian?
father.
Kept in custody of his father, namely Babu Das, on such terms and condition as deemed fit by the Juvenile Justice Court. Vishwanath Sarai. Juvenile Justice Board. Vishwanath. Vishwanath. You have to again approach JJP with this order. Let this case be listed again on 4th of February.
12th of February.
12th of February.
Outline.
Outline. এখানে
May I please, my lord? May I please, my lord? This is a 482 application, and by this application, I am challenging an order dated 13/7/2023, passed by the Special Judge CBI. Now, my lord, by this order, a charge has been framed against the accused under Section 7. Now, Section 7 of Prevention of Corruption Act stands for illegal gratification taken by a public officer other than legal remuneration. Now, to satisfy the ingredients of this offense, there are two key essence to satisfy the ingredients of this particular section. First one is the demand, and the second one is the acceptance. Now, my lord, demand is the sine qua non. It has to be established. If the prosecution tends to fail to establish demand merely by proving recovery, acceptance, or taking the money, is not going to satisfy the prima facie case under Section 7 of the Prevention of Corruption Act. Now, my lord, to satisfy my lord that there is no prima facie
Who
case
is
has been able
respondent
to
number two?
establish.
In this case, notices are yet to be.
Yes, my lord, notice has been served to CBI.
Who is the informant, I think? Who is the informant? Also, in this case, we'll file a written objection. It's already ready. We are
My
going
lord,
to file
today I
it
am
by
pressing
today.
for stay of the further proceeding.
Lordship already fixed for evidence, Lordship.
No, it may be fixed for evidence, my lord. There is no.
Then
bar
what
under-
is the urgency of the for the interim?
No, my lord, because
You are otherwise appearing, you are facing trial.
my lord,
You are facing
Yes,
trial. You
yes,
are
my
appearing.
lord, I am I might be facing trial. Only one witness has been examined in this case.
No, you have to explain what is the urgency. Would not
Prima facie case.
entitle you to get an interim plea
My lord,
unless there is an urgency.
no, my lord, there is an urgency because there is no prima facie case that has been established.
That is the reason cause.
Yes, my
I am asking about the urgency.
lord, that is one of the.
You may have a good ground for quashing, but
Lord,
that has to be
under 482.
considered.
Yes, my
No,
lord.
that
But
we will consider at the time
under
of final hearing.
482, an accused person has a right to place this before this honorable court that the prosecution has miserably failed to establish a prima facie case. And my contention of argument would be just to that regard only. I will not go any further.
Whether all materials are there before.
Yes, Lordship. It's a trap case, Lordship. He has been
No,
apprehended.
no. Whether the lower court record would be required.
Lordship, if the Lordship goes to the petition itself, as
It
well as
is
the,
there.
it's enough, Lordship.
LCR is not required.
Not required. Lordship. They have
Okay.
already annexed, Lordship. We'll also, in our written objection, will annex all the document, required document, Lordship.
And the 161 statement,
161, they have annexed.
I have annexed.
They have annexed.
all
No,
161.
all, my lord. I have annexed the 161 statement of the informant, IO, and 2 police officers from CBI, and 1 independent witness. I think this is enough to
Okay.
consider whether the prima facie case has been made out of.
Okay, let them file the objection.
My lord, if they are allowed to, my lord, make it a short case.
Yes, yes.
Or Mr. What is your name?
My name is Peter Kamal.
Heard Mr. P. Deka, attended counsel for the petitioner. Also heard Mr. M. Halloy.
SLPP.
Learned Special Public Prosecutor, CBI. We have not yet issued notice to respondent number 2.
But today I will take the.
So for that,
Yes.
order has to be passed
Yes,
for
yes,
issuance
yes.
of notice.
Today, for the first time, it has been.
But it is not necessary to consider interim matter that his presence is required. Otherwise,
Issue
notice is
notice,
mandatory.
issue notice to the respondent. As learned additional public prosecutor, as learned special public prosecutor CBI has appeared for respondent number 1, no formal notice need to be issued to the respondent number 1. As regards the respondent number 2 is concerned, the petitioner shall take steps for issuance of notice on the said respondent by registered post with AD within 3 days from date of this order, returnable after 2 weeks. Learned special public prosecutor has prayed for some time for filing a written objection against the prayer of the present petitioner. The prayer is allowed. Let this case be listed again on
18.
My lord, one more thing may be added, that on next date, the prayer for interim meeting shall be.
18. 18.
let this case be listed again on. You have to take steps for.
My lord, today I will take.
Let this case be listed again on 18th of December, on which date the prayer for interim relief would be considered by.
Keep your blame.
27.
May it please your lordship. Your lordship, petitioner before your lordship is the officer in charge of a police station who was conducting his official duties and discharging the official as a public servant, lordship. Before placing the interim complaint, lordship, I'm placing the first GD entry and complaint, where the root cause of the subsequent complaint, which is impugned here in this petition. So lordship may kindly.
No, there was a application from your side for impeding someone.
Yes, that affidavit we have filed to add the respondent number 2 as an party number 2. We have filed our affidavit detailing the facts. No, we have paid that may be accepted.
No, you have filed in one affidavit,
Yes, Lordship.
but
For adding respondent, respondent number 2 as party respondent.
by affidavit you cannot add. There has to be prayer.
Yes, Lordship. Otherwise, so we have filed one impeachment application also.
Yes, you have to
That
file an,
if you're, yes, already filed, if that is also filed.
that has to be,
If your Lordship takes
considered.
up it sometime, I may be, because there is certain urgency in this matter, Lord.
No,
If your Lordship
urgency
takes
may
up,
be there, but it is on your prayer. You prayed on last occasion that one party complainant has to be implicated as,
we have filed that, Lordship.
that is not
And-
before this court now.
Yes, Lordship may call for that, this after, Lordship may take up after some time, we have filed that also.
Let us fix it tomorrow,
Tomorrow is
Because-
Saturday, Lord.
because that has to be allowed first. Then he has to be impleaded. Then only we can hear your main petition.
And as the last item may be taken up this, because we have already filed, we can file, is tagged with the record.
Okay,
Today
call
itself.
for the impleadment.
I'm obliged, Lord. Today's last item, Lord.
Okay.
Obliged.
Item 11,
Merely clear your lordship. This court application I filed. This come to impugn order first, my lord. I'm not the 120, my lord. It's all about framing of charges, the procedure and the techniques. How this framing of charges has been framed by the court. That I have challenged in this petition because the procedure and the technique is not maintained by framing of charges. I've just read out, my lord.
At
What?
page,
120. Yeah, we lordship goes to 120.
yes,
Today, the case is fixed for remand and constitutional charge and constitutional and bail. Although, today case fixed for remand and constitutional charge and constitutional bail, this para itself is wrong because if you lordship go through the last order, page 119, fix a 10/5/23 for remand, appearance, constitution of bail and SC order. No date has been fixed yet for constitution of charges.
Heard on point of charge.
Hard, already hard.
Ah.
Again, even the previous order, there no such way on the consideration of bail, all bail. No, I just read out. This is the one aspect I was just pointing out. So I don't, now, accused Dura Chandra Das, Ajay the Burman, Deepak Vista, Abhay De, Anil Malan, Sajab Raja Para are produced before this court through video conferencing and on being queried by, they have not complained of any health issues. Hard learned public prosecutor, learned advocate representing the accused person of matter of constitutional charge. After going through the case second relevant material, giving my insights consideration to the submission made by both the parties, I have to consider an opinion that there is sufficient material to presume that accused Akshay Kumar De, Deepak Das and Ajay Burman have committed an offense punishment as 212-34 Indian Penal Code. The charges under section 1-212-34 of the Indian Penal Code have been read over and explained to the accused Akshay Kumar De, Deepak Ajay Burman in their language, to which they have pleaded not guilty and claimed to be tried. After going through the case record and relevant material and giving my insight consideration to the submission made by both the parties, I have a considered opinion that this is here on the petitioner. I have considered that there is sufficient material to presume to accuse Buldi Chakraborty, Dulal Das, Pandak, Kumar have committed an offence punishable under section 120B, 307, 326, 31 India Penal Code, AD section 27 of the Arms Act. Now, my lord, here the question comes, I am the petitioner, I am the Bunti Chakravarti. Now, if your lordship go through this is very big order. Now, if you read 124 page, my lord, so many charges and the petition, bail petition, so and so. Considering the fact the charge has been framed that this court is your consider open the accused continued custody of. So, no. So, my lord, so there no conclusion has been drawn. How there the case has been framed? What is the presumption? And what are the materials available on record on basis of which the alleged session court has framed a charge against the accused? Has framed a charge against the accused? No material constitutional. This is not a mini trial, my lord, but at least some presumption has to be drawn because the section itself, if I read the section, there are so many Supreme Court judgments, my lord. I will come in one after another. That has not been explained. First, my lord, if I read that 226, opening case for prosecution, when the accused person or is brought before the court and pursuant the commitment of case under section 229, the prosecutor shall open his case by describing the charge brought against the accused and stating by what evidence he proposed to prove the guilt of the accused. What evidence he has to plead, that has to be explained is in the order itself reflected, but no reflection has been done. On what basis? It is stereotype mechanical order, just it's like a check bouncing case. Yes, I frame charge under section negation instrument act. This is like that. 220, if I read the 228 sections, my lord, framing of charge, how the charge is framed. If after such consideration and hearing, as aforesaid, the judge is of opinion that there is ground for presuming the accused has committed offence, for presuming, that presumption is there. My lord, if you lordship go through presumption, what presumption? It has to be explained in the order. I just read out, my lord. I just read out, my lord. If I lordship go through my petition, my lord, although the order judgment has not been reflected, my lord, but I can just show you, my lord.
No, what is your grievance?
My grievance is that I have not given charge. I have not given time for discharging, for filing discharging petition. Neither I have been given time to for preparation for giving for hearing of the for framing of charges, my lord. No consideration. Suddenly the court has taken. There no date has been fixed for that. Suddenly the court says, okay, I will file today. I will hire down the charges. So I am not prepared. First thing I should have filed. I have good an opportunity for filing a discharge petition. That opportunity was not given. My lord, if I lordship go through it, there's so many judgments, my lord. First, I learned what presumption. This itself is wrong, my lord. Order itself is wrong, because presumption has not been given. Here, how is there? What offense I have committed? All that section has been given. On the other hand, the main accused, against whom he is the charge has to be framed, that has not been charged. He has not framed on the charges. Simply, I just read out one after another, my lord. Anil Malakar is the main accused. Here he has been charged only under section charging fraud against him under.
No, Mr. Moitra. You're Mr. Moitra.
Yes,
Mitra. You have to be clear about on what your first grievance is that without fixing the case for consideration of charges were framed without affording an opportunity
of giving heart
of hearing. But order sheet reflects that you have been heard.
Order sheet reflected. That is what I am telling you, my lord.
Consideration to the submissions made by both the
parties. But that is what I am telling you. Suddenly, if I come in the court, I say that today I am going to, should given today I will pay, I will hear on the basis of charges. This is not possible because I have.
No, you could have prayed for time.
Because, my lord,
Court is insisting that court will frame charges. You could have prayed for time.
that is the lapse of the advocate. I do admit, my lord. But I should have given chance for discharge petition. That is the lapse of the advocate. But thing is that, my lord, I just, but if the order is erroneous, my lord, if there is
How order is there?
because the way the procedure, the presumption has not been properly explained by me. How the charge has been framed, what the particular sections were given. See, the simple one example. Gateway section 27 of the Arms Act. If I go to the enter, then I have to go to the enter summary of the case. Fulti Chakraborty, 27 of the Arms Act means I should handle a weapon. I have not handled any weapon to kill that accused, to kill the informant. Because I don't have any gun. Only thing is that I am just instigating. That is the allegation against me. How I have been charged, that he is not applying in judicial mind.
So your one of the ground is without material charges are met,
Yes,
without
my
there being sufficient.
Yes,
detail.
yes.
Is that your ground?
Yes, my lord. Yes.
Who is
One of the ground.
Who is respondent number 2?
Informant.
Let us issue notice.
Otherwise, the order shows there is no
I do
defect.
not. What kind?
Upon consideration of the submissions
Yes.
made and on perusal of the records, charges are framed. And in the earlier order that he had said that it was not fixed for consideration of charge. But in the earlier order, it's written that
Hearing
it's
first.
heard on charges and next day will be for necessary order. Necessary order, what is there?
Because I am not finding any prima facie error.
He could have taken time, as your lordship said.
I will get read out, my lord.
And then the lordship will see the remaining papers where charges were framed with heads. There's nothing wrong in the.
I will read out, my lord. How the court has not applied in mind, my lord. If I go to the FIR, my lord, page FIR and charge framed by the police. Page 52.
No, you have challenged the order dated
10-1.
10 You
10-1.
have to show defect in order dated 10.
Yes, defect. That's just what I'm going to defect. I'm just read out, my lord. How the court has doesn't apply his mind, my lord. I don't want to quash don't want to quash the interpret. Only thing I should give it a fair chance. Because the judgment is there from the Supreme Court. I can just
No, but
for the
prima
sake of
facie
argument,
record shows that chance was given, you were heard, and thereafter charges were framed. Because on 6th of May,
my lord, I'm just read out, my lord, how the court has doesn't apply this same, my lord.
okay, we are issuing notice.
Notice, only the notice.
How,
Lordship.
Mr.
My lord, that 13-12 is the date. Only for one day, my lord, till that a notice comes. Only for that day, if the only prosecution witness starts, then the framing of charges will it will can be influctuate. So for that particular day, 13-12, the particular for the timing stay may be done, my lord.
No, stay.
Before 13-12, it can be listed.
No, even if for stay, you have to show something.
Yes.
Prima facie something you have to show,
Yes,
which
yes,
you are
I must
unable
say
to show.
So, my lord. Page, if you lordship go through page 97, my lord. You just lordship go through that page, where is the defect? Criminal conspiracy. Criminal conspiracy. During investigation of the case, I just read out, my lord.
No, to consider these submissions, we have to go into depth. We are issuing notice.
Thing is that, my lord, what happened? I want to show this thing because the prime accused, he has not framed by only minor charges has been framed. But Supreme Court says the stringent of punishment, stringent section has to charge charges framed first. But here, my lord, so far only Malaka, who is the prime accused, he is only charged with negligible section.
The trial court had seen and found out now.
But
High court cannot.
this is the defect. The police says that no, he is the main accused. He is the person who fired with his revolver. With criminal conspiracy involved, but he is not involved.
Then in that case, he's going to the merit of the case. The charge framing was wrong. Not
That's it,
technical,
that's what I'm doing.
not technical.
Yes,
technical.
that is what I'm
Heard
doing.
Mr. S. Mitra. Also
The technical part
heard
was
Mr.
not
S.
quite
Mitra,
verifiable.
learned counsel for the petitioner, also heard
Yeah,
Mr. Jahan,
yeah.
an additional public prosecutor. This application under section 482 of the Code of Criminal Procedure has been filed by the petitioner, namely Srimati Bulti Chakraborty, praying for quashing and setting aside. Is it quashing or setting aside?
For setting aside, not for washing, my lord, but setting aside. Possibly. Setting aside.
Both are not same. For setting aside, the order dated 10/5/2023 passed by learned Sessions Judge Bojai in Sessions case number Sessions case number
Session case number 24, H of 23.
within bracket 1,
1,
24,
H,
One.
within bracket H.
within bracket 1, thereafter after bracket 24, then within bracket capital H of 2023, whereby charges under section
Other sections. 1.
charges under section 120B slash 307/326/34 of the Indian Penal Code, read with section 27
1
in
of the
bracket 1 of the Arms Act, were framed against the present petitioner. Issue notice to the respondent. Issue notice to the respondent. The as learned additional public prosecutor has appeared for respondent number 1, no formal notice need to be put. Respondent number 1. As regards respondent number 2 is concerned, the petitioner shall take steps for issuance of notice on respondent number 2 by registered post with ID returnable after court. Let the scanned copy of the case record of sessions case number 1, 1 within bracket 1, then 24 within bracket H of 23, as well as scanned copy of the tumbling PS case number, scanned copy of the case diary of lumbling PS case number 196/22. We call for registry shall take step for procuring, requisitioning the scanned copy from the trial court. Let this case be listed again after court.
After 4 weeks. But in the meantime, at that 13-12, the witness will, will start. So
Let-
at least for 1 day, my lord, at least. So
No,
that the
this
date may
is-
be there. After that, my lord, I have no, because if you start, then the charge cannot be changed, altered later on.
Charge can be altered at any
Any time, my lord. But the thing is that the basis on which I should have given a chance for fair to,
No, then I have to observe that there is no prima.
there is no prima facie, my lord. I'm
Yes,
telling you, my lord. But they should have given a chance, my lord. I know. But thing is, I've just pointed, but he's my learned friend is telling that I'm going on the merit of the case. This is the prima facie, my lord. The prima facie is that the main accused is main accused.
No, he is going into the marriage, so
At
we have
this
to see
stage-
the
at this stage,
173 documents.
This court does not find any case to grant any interim relief. Let this matter be listed after court.
Lodge.
Item 12,
But that order will be given if of course. But if I file a petition for that matter is pending. So since the matter is pending, particularly subsidiary matter, it is up to the court to decide whether the court will.
There is no bar.
There is
Trial
no
will-
bar, my lord.
Trial will proceed.
That observation, at least it is some observation may be here so that they cannot take.
What
Yeah.
observation?
That court may, but a court may go for further proceeding or may.
The pendency of this criminal petition would not be would not be treated as any, would not be regarded as any bar in further proceeding of the sessions case number so and so pending before the court of London. It will proceed.
Huh? Man, this will that if I file a petition, then the court will not go through that. He will go on this petition. This order is against me, my lord.
Therefore, you have to be very careful while making.
No.
The
No,
last line.
I just want that the court should submit minus the at least. Okay, anyway, my lord. I
The
don't want
last
to-
line can be omitted.
last line can be omitted. Man.
That's like,
Lord.
after court.
Item 12,
My opinion, 482 system for pursuing the FIR. My lord, kindly the page number 32,
Page number
32, that is FIR. And excerpt 6, my lord.
it's pending investigation.
My lord,
Charge sheet has been
no, my
laid,
lord, no, my lord.
pending investigation.
My lord, what happened, my lord? My lord, on 14/12/2022, my lord, the police person recovered an amount of rupees 19,99,500 from the possession of the present petitioner. Man. Thereafter, my lord, petitioner along with other 3 persons were arrested and sent the judicial custody. Case has been registered under section, my lord, case number 33, my lord. Under section 120B, 420, 413, 34, IPC, repeat section 4 of Prevention of Money Laundering Act, my lord. My lord, thereafter, my lord, kindly the case number 40, my lord. Case number 40, my lord. Page number 40, my lord.
Yes.
FIR was made by IO for the violation of section 4 of the Prevention of Money Laundering Act before the Elaka Magistrate, which was also accordingly allowed. Section 4 of the Prevention of Money Laundering Act was deleted. Now, my lord, in this case, my lord, remaining section of my lord 420 and 413, my lord,
420 and
and 413. If, my lord, there is a section 420 and 413, my lord, 413, my lord, there must be an incidence available. That is, my lord, there should be a fraudulent or dishonestly inducement a person by distributing of the him, or a person through inducement should be intentionally induce or deliver any property to any person, or to consent that any person shall retain any property. The person to induce to do anything which would not do or omit if he were not so disciplined. My lord, case is, my lord, simple, my lord, the money was recovered from the possession of the petitioner, my lord. They are not applicable, my lord, section 420. Secondly, my lord, as per the Honorable Supreme Court judgment, my lord, kindly see the page number 41, last para, my lord. If the section 413, my
merely
lord,
because some money was recovered.
yes, my lord,
No other allegation.
no other allegation, my lord. Nothing is, my lord. 413, my lord, 413, not applicable, my lord. My lord, if 413, my lord, the subject matter of offense was stolen property, should be. The accused received such property. He deal with his such property. He did it habitually, my lord. 413.
413 is habit.
Nothing else, my lord. For which, my lord, I have applied this criminal petition quashing the FIR, my lord. My lord, neither the recovered money from the possession of the accused person is a stolen property, nor the accused person is habitual offender. My lord.
What is this order at page 40?
Yes, yes, 40.
This is a bail
This
order.
order, yes, ma'am. This is a bail order, and my lord, this order was passed by the my lord.
No, where section 4 was deleted by which order?
Yes, my lord. And it's the page number 40, madam. Page number 40, madam.
It is 39.
There is, my lord, middle portion, my lord. There are clearly when there is a no specialized complaint by any specialized victim claiming the cheating by the accused person and claiming the right and the ownership over the seized item. Moreover, when the seized amount is not found to be a proceed of crime, my lord, by IO, my lord, for which the payer was made IO for the deletion of the section 4 of the Prevention of Money Laundering Act before the elected magistrate, and which was also accordingly allowed. Apart from that, my lord, date of filing FIR, my lord, almost 1 year completed, my lord. Whereas the as per section, my lord, the state will be filed within the 60 days, my lord, within 2 months, my lord. 1 year completed, my lord. Till today, my lord. Neither file final report nor my lord.
We'll call for the
In fact, this is a bail application only, and in this application, they have
observation.
obliterated section 4 of the money laundering in this particular application. But in the FIR, there are allegations that there was a fake process of business transaction, and these are proceeds of that.
But number 4, section 4 is not there.
Section 4 is not there in a bail application, and
Record has to be gone. We
Yes,
have to see the case.
yes.
Suppose section 4 is not there,
Hmm.
then there has to be ingredient to 420
413.
or 413.
413.
Yes.
413 is stolen money, any proceeds from stolen articles.
So there has
So-
to be some material. So
In the FIR, Lordship will see second paragraph. They also stated that many businessmen under Dhubri market are also directly, indirectly involved in this money transaction, showing fake process of business transaction gaining illegal benefits, as stated in the statement of the accused person. The accused person is in a very smart manner used their mobile phone, WhatsApp, and money is also very
No,
large amount.
actually, what is the allegation in the FIR? Gist of allegation.
Gist of allegation, what I find, these proceeds are from fake transactions, which people are indulging with.
No, my lord. This FIR was lost by the IO, my lord, not public, my lord, third person, my lord. And here, my lord, if
As
there is
a-
a money transaction, my lord, then section 4 of Prevention of Money Laundering Act should be here, my lord.
Section 4 to no.
Already deleted, my lord, section 4 of the Prevention of Money Laundering Act, my lord. And even in case, my lord, there is a no specific victim, my lord, who has been treated by this ex-person, my lord. No person, my lord. Till today, as a my lord, 1 year completed, my lord.
Okay, let us call for the case.
Lordship. Yes.
You are on bail.
Well, my lord, within 15 days, my lord, we are released, my lord. Within 15 days, date of FIR, my lord.
Heard Mr. S. Rahman, learned counsel for the petitioner. Also heard Ms. S. or S. Jahan, learned additional purpose. This application under section 482 of the Code of Criminal Procedure has been
What
filed
for?
by the petitioner, namely Suleiman Ansari, praying for quashing the FIR dated 15/12/2022 on the basis of which Gauripur PS case number 447/2022 was registered under section 120B/430/20/413 of the /34 of the Indian Penal Code. Issue notice to the, who is respondent number 3?
My lord, he is a landlord, my lord.
Yeah.
My lord, my lord, an agreement for sale the land, my lord. The landlord, my lord, this was 3, my lord. An agreement was executed between the petitioner and my lord. Respondent number 3, my lord. For which, for my lord, the payment of the value of the land, my lord, the petitioner went to the place of the petitioner house, my lord, with cash money, my lord. That is, my lord, wrong, my lord.
Why have you made him a respondent?
Because, my lord, he has to reply, my lord, because that agreement was happened or not, my lord. That is, my lord. It is original fact, my lord. Due to his daughter's marriage, my lord, he need to money, my lord. That is why, my
Issue
lord.
notice to the respondent. As done an additional public prosecutor has received notice on behalf of respondent number 1, no formal notice need to be issued to respondent number 1. As regards respondent number 2 and 3, the petitioner shall take steps for issuance of notice on the state respondent by registered post within 3 days from date of this order, returnable after court. Let the case diary
Lordship, I'll bring it.
Let the case diary of Gauripur PS case number 447/2020 be called for. Fixing
December
January,
20th or
January.
January? January 10th.
Before vacation, my lord.
No.
He's suffering, my lord, various problems, my
How
lord.
you are
But
suffering?
Close, my lord. He's a businessman, my lord. Close his grocery shop, my lord. All amount, my lord. Yeah, my lord.
No,
That is
how
his
you are
suffering.
suffering? You are on bail.
No, my lord. Monetary suffering, my lord. My lord, my earnings was the shop, my lord, grocery shop. That amount might receive from the grocery shop, my lord. The shop is
That
already.
amount
No,
has
he
been
can-
seized.
He can pray for custody of that amount.
Yes, my lord. My another submission, my lord.
Before,
My lord.
not before this court.
My lord, yes, my lord. There is a my lord. I am coming, my lord. My another pair, my lord. Already one petition, my lord, is pending, my lord. Before one of this Guwahati High Court, my lord. Already notice issue, my lord, for my lord, quashing the Zimma petition, my lord, order, which is order passed by the registered
That
on
can be
Zimma
seen.
petition. That petition, my lord. Please may take this in this matter, my lord. That petition number, my lord, 1192, my lord. Female petition number 11.
No, those are separate matters.
Yes, my lord. Prayer is a separate matter. The Zimma petition, what for the Zimma petition, my lord. The order, this is order passed by that.
When that is fixed.
My lord, after 2 weeks, my lord. That order passed, my lord.
2311.
22,
No.
my lord. 22/11, my lord. Within 2 weeks, my lord.
So it will come, that matter will be
My lord,
listed.
after 1 week, my lord, it's possible.
Let this matter be listed after 2 weeks along with criminal
Criminal
petition
petition
number
number 1192 of 2020.
1192 of 2020.
Hello.
That's
13,
May please. But we have put 38 application lodged. The FIR lodged will find at page 9 lodged. The allegation lodged, there was a assault from both two sides lodged with regard to a land dispute lodged.
There is a death.
And one person from the informant side lodged succumbed to the injuries lodged. And this petitioner lordship, he being a relative of the other accused or co-accused lordship, he was only present there lordship. I will take lordship to page 26 lordship. Page 26 of my bail application.
Yes.
Third paragraph like that bail application was for one nominally lordship, and that was rejected. And in that lordship, the version of the injured eyewitness is recorded lordship. Let's see. The injured eyewitness specifically implicated the present petitioner. Present petitioner is nominally, along with one Joinuddin Ainuddin, and stated that these persons inflicted injury on the head of Mohuruddin with bamboo sticks, who subsequently succumbed to such injury. The injured witness further stated that the present accused, as well as Joinuddin, Ainuddin, and Fakhruddin, rebuked him, and Fakhruddin gave a dow blow in his head. His name was not there, although he is named in the affair. He is the paternal uncle of this person.
That is a bail application
Observation.
in respect of someone else.
Because that bail application, this case diary would be perused
Yes.
in consideration.
After case
of
diary,
that.
that was well in the rejection order it is.
No, but at the time of perusal of the case diary, that court would peruse the case diary in respect of the petitioner who is before the court, not in respect.
But although he was named in the affair lordship, his name is not.
Perusal of the case diary would be.
Okay, lordship will call for the case. Lordship will call for the case diary. Lordship. Case diary was already here because lordship has yesterday. Lordship has disposed of one application. Lordship. Yesterday.
Okay, we'll fix it.
Next week. Lordship.
Okay, if case diary is available in the,
Yes.
it will be in the.
He was in custody.
If it has not been taken back, then okay.
Yes.
Next week,
I'll
Tuesday, Lordship.
I'll retain the case diary and.
Third,
Yeah, ma'am.
Mr. A. Mohammed also
Case number
admits
one?
it's Jahan,
Etuta actually case
learned
number.
additional
So,
public
no,
prosecutor.
T1
Considering the nature of
down.
allegations level in the FIR, the result of the case diary report hence call for the case diary. See? When it can be picked?
and next week, any day, I mean, Lordship will fix it on 7th, 8th of December,
8
Thursday.
December.
Friday,
Friday will be difficult on 7th.
7th.
Okay, 7th of December.
14.
May please your lordship. The Counter-FIR application lordship. Lordship petition before you lordship is a licensed assistant and takes the record of Sonara Municipal Board lordship. And one executive of Sonara Municipal Board lordship lodged a FIR against the petitioner regarding the misappropriation of office money lordship. Can you see the page FIR page 11 lordship?
Yeah.
Married lordship. Married.
Yeah.
With reference to the subject site above, I have the honor to inform a lodge FIR that Sri Santanu Sekhar Sengupta, Ward number 12, Sonare Town, Bhavani Post and Thana Sonare Sarada is a regular employee of Sonare Municipal Board. He was entrusted the charge of tax, Taroga property tax, trade license, matter and house rent collection from the office. He is found involving in misappropriation of office money more than 4. An amount of rupees so-and-so has been detected irregularities by the AG audit party in the last month and more than 70 lakh rupees found irregularities by the office preliminary inquiry later on. Besides that, 6 number of receipt book containing 100 leaf pen each have been found missing during the period between 22 31 7 23 only. On the same date, lordship, kindly see the page 20 lordship. Issue a focus notice by the executive officer, not Sonari lordship municipal board to the petitioner. Kindly see page 20 lordship. From Palas Rajkumar, this is executive officer to present petitioner. Issue subject focus notice regarding misappropriation of office money. Lordship. On the subject side above, Sonari municipal board want to inform and let you know that the irregularities of office money has been detected in the last month by the AJ audit party period between so and considerable reply could not furnish by you. Later on the office investigated all the receipt book submitted by you and found irregularities of more than 70 lakh of rupees in the period between 1 April 2021 to July 21. So you are direct to reply within 7 days from the date of receipt of this letter.
No,
Here
only
in
the
this case, lordship, issues focus notice to the petitioner on the same date. The executive officer lodged a FIR. Here in this case, the petitioner given 7 days time to submit his reply, to submit his the documents regarding the irregularities. But on the same date, his executive
No, but allegations are of misappropriating
huge amount of
huge
money.
amount.
lordship, because
So
I
only case
cannot,
diary will
I
do.
cannot go to the office due to the loss of FIR. Everything is in the office, lordship. If I may be allowed to protect lordship and I submit all these things, but regarding the finding no other alternative lordship, I reply the said notice lordship or through register post, that is page 21 lordship. Yeah, lordship, kindly see page 21 lordship.
Asking for more papers, more
More,
details.
I am asking for said anonymous paper lordship, but I have not given the opportunity to submit that paper. My humble pay before you kindly give me some time lordship. I produce everything before the police as well as executive officer lordship. And in the lordship also, petitioner also suffering some illness lordship regarding the shortness of
No,
death.
we will fix a short date. We'll go through
Finally,
it.
feel that I may protect it. Otherwise, I cannot submit everything, lordship, and against me, lordship, everything goes against me. I am also suffering shortness of breath, lordship. I have my next medical report, lordship, page
This is
23.
a disciplinary inquiry that will go on and then here, let us produce the CD because embezzlement of a
Till
huge
the time may be protected, lordship. Otherwise, I cannot produce the dead documents and everything against me, lordship.
No, therefore, everything is against you, therefore.
That's why I am go to the office, lordship, and find out the every document and produce before the IO, lordship. I am a government employee, lordship. Why I go, lordship, and is a local resident, lordship.
No, let us peruse the case. You are not saying that you are innocent.
I'm innocent, lordship. Lordship, I am also. I'll see the prior there, lordship, page 20, page 14, lordship. The chairman of the municipal board, lordship.
Why he has filed? What is your response to the allegation made against you?
Lordship, I am ready to submit that documents, lordship, but they are not given on the next day, same day. They file a FIR. How can I go to the office, lordship? If I may appear before in the office, I may be arrested, lordship. That's why I am before you, lordship. And earlier, lordship, the chairman of the letter regarding the measure, I have also submitted some of the documents, lordship, before the here page 17, lordship. I submit some of the documents. Again, executive so issue and issue law the FIR also, lordship.
You have the relevant document.
Lordship,
You can justify.
lordship. That document is in my office, lordship.
But you have failed to produce it before the audit officer.
Lordship, no, lordship. I on some time, lordship. There is a 2020-21. That is, I have to find out the everything, lordship. I have need some time, lordship. There is a in a file.
Yes, Ms. Jahan, what is the
I mean, one day thereafter, he gets the charge, he gets the notice.
On the same day, lordship. File was a FIR, lordship.
Perhaps his documents are in his office and he is not able to go there.
where is your
And petition also suffering some illness, lordship, and doctor also advise him to.
no, ailment may not help you because the allegation are of misappropriation of huge sum of money.
That is true, lordship.
If that allegation is
But
true,
I have a documents, lordship. I want to produce, but that opportunity I have not given, lordship. My humble paper, that
this
opportunity
is
may be filed,
irregularity.
lordship. On the same date, 1/11, token notice also issue, and on the same date, FIR also. How can go the office, lordship? I may be arrested if I
Okay.
go.
In this case, in preliminary inquiry, irregularities were found. So
There's no issues of notice. They have to wait 7 days, lordship. But they are not wait. They on the same date they lodge a FIR.
Because by then preliminary report came.
That's why that's why I filed a reply, lordship. I have a document and so I want to submit, lordship. I have a reply also to register post. I'm seeking also the details of the documents with anomaly. Still that I may be victim, lordship. If anything against me, lordship.
case diary, we are fixing a short date.
Still that lordship kindly allow me interim, lordship. And if anything against me, my paper will reject it, lordship. At least my humble pair, lordship, will kindly grant.
You are protected since last 1 month. 1 month, police could not arrest you.
No.
You can wait for 7 more days.
Yes. On 11th of December.
Out, Mr.
Be Islam, lordship.
B. Islam, Learned Counsel for the petition. Also heard Ms. Jahan, the petition.
Lordship, if I'm not go to the office, lordship, that they are I cannot
Let us see.
submit, lordship.
Let us see.
Kindly, lordship, allow me 7 days time, lordship. In the meantime, I may maybe fix 11, lordship. till that I may be protected, I may go to the office, lordship, and find out the said documents, lordship.
That
Otherwise, I
will-
cannot prove myself, lordship.
That he can do after 11th or 11th.
On 11th, you make prayer.
I may be arrested, lordship, I will.
No, no.
I may be arrested, lordship.
Considering the nature of allegations leveled against the present petitioner in the case diary, perusal of the in the FIR, perusal of the case diary would be necessary for consideration of the instant bail application. Hence, call for the case diary fixing 11th
12.
December.
Because my treatment is going on, that's why I'm not to go to the.
On that day, you may make prayer. Let us
Kindly till that moment, lordship, I may be gone.
know, because huge amount is involved. Huge amount of involved, and
That's why I may pay
you are not
myself,
sure
lordship.
that you are innocent or you are really involved.
I am not cooperated with the investigation, lordship. How can I prove myself, lordship?
Wait till 11. I have passed the order.
11th or forgot it.
Abla,
15,
my appraisal. Case 9 is the FIR, Your Lordship. Herein the allegation is that the informant he has alleged that the petitioner committed rape to her. And the alleged incident took place on 4/11/2023, but this FIR was lost on 12/11/2023.
Case diary would be
Lordship, yes.
required.
Case
He has
15, Your
also
Lordship, there
injured.
is one more FIR, Your Lordship. It was lost by the elder brother of the petitioner, Your Lordship. Case 15, Your Lordship, kindly have. Actually, on 4/11/2023, the petitioner was assaulted by the husband of the informant, Your Lordship, and some other.
Page 15 is the FIR lost by
us, Your Lordship.
when? After she had filed.
No. Before 1/5/11/2023, it was lost, and the FIR lost by the informant on 12/11/2023. Although
But after the alleged incident,
after the Ellis incident was taken place on 4/11/2023,
you lost
and he lost the FIR on 12/11
and you lost the FIR on
on
5.
the next day, 5/11/2020. The petitioner, he was badly assaulted, Your Lordship. He got admitted in GMC as well as some other private hospital in Guwahati, Your Lordship.
Oh, petitioner.
Yes.
Maybe because of the alleged incident.
No.
We have to peruse the case diary
No.
because of the.
Your Lordship I have no objection, Your Lordship, but kindly have a look our FIR, Your Lordship. Please at page 15, Your Lordship.
No, but your FIR was also after the incident.
No, on the next day, Your Lordship.
After the alleged incident
was on 4/11/2023. On the next day, Your Lordship, 5/11/2023, this FIR, Your Lordship. And their FIR, Your Lordship, on 12/11/2023. In page 15, Your Lordship, it was on 5/11/2023, and the Ellis incident was on 4/11/2023.
No.
And in their FIR also, Your Lordship, they have admitted that the petitioner got injured, Your Lordship. Yes. In their FIR also, in page 13, Your Lordship, kindly have a look. I'm reading the whole.
No, that may be in an offense like rape. It may be followed by another offense by assaulting the.
No. No rape was committed, Your Lordship, just to save from the liability of our FIR, Your Lordship. This FIR has been lost, Your Lordship. Because of that, Your Lordship, they lost FIR 1/12, Your Lordship. Although the Ellis incident was on 4/11/2023.
Here the
And
timing
our
is
FIR, Your Lordship, on the next day, Your Lordship, and police recovered the petitioner, Your Lordship, from the accused person, Your Lordship. And thereafter he was admitted in hospital. All the medical reports and prescription relating to the injury of the petitioner, Your Lordship, I have annexed at page 21 onwards. And in connection with our FIR, Your Lordship, the husband of the informant.
Mere filing of FIR is not sufficient.
Now the question is.
Fact shows the the informant was raped on 4th and you were assaulted by her husband after the rape. That is
No.
that is
I was assaulted by the husband of the informant. Your Lordship.
that what I am saying, that you were assaulted by husband of the informant after the incident. That is the allegation made in her FIR.
No, but then the
But-
timing is, I think, different. Lordship will say 6 p.m. The assault was made on 4/11, 6 p.m. and 8:30 she is alleging of the rape. 8:30 p.m. That is after 2 hours. I don't know.
No, in
Had
their
there been
FIR,
any rape, Your Lordship, had there been any rape, Your Lordship, then the informant would have certainly lost the affair on the next day. But why he lost this affair on 12/11/2023? But our case, Your Lordship, on the next day, Your Lordship. And in connection with our case, Your Lordship, the husband of the informant, he was arrested. That is case 30, Your Lordship.
yes.
Still the petitioner, Your Lordship, is under treatment, Your Lordship.
No, it seems on 4/11, 2 incidents took place. 4/11 at 6 p.m. this assault took place.
No, that is their allegation.
That is their
That
allegation.
is their allegation. It may be true, it may be false.
False, yes.
In the present FIR may also be true, may also be false.
No, why I'm saying this, they have said, I think,
That is
he is, তুমি কোন হয়?
Moi-
তুমি, you're Basar Ali
our
Khan.
at 6 on 4/11/2023 at 6 p.m. Your Lordship, incident took place, Your Lordship. And they stated in their
That is
affair
what I said.
4/11 on same day, but at
8:30.
8:30 p.m. Your Lordship.
That is what I said. দেখুন,
Subsequent to
you're Bahadur Khan, no?
no, Bahadur Khan is there.
You're Basar Ali.
Now this affair kindly see, Your Lordship, on 12/11/2023 they have
No, there is apparently a delay.
Apparently a delay, but then this 6 and 8:30 is as if this is an after, it's an incident,
But this timing is given by two different parties.
2 different parties. But we have to see whatever is written there, we cannot.
petitioner, Your Lordship, is still is under treatment, Your Lordship.
Where
At present, he is in home, Your Lordship, but under treatment.
you are not arrested.
No.
Then why are you apprehending it?
No, apprehended because the case has been registered against me, Your Lordship. Police may arrest, Your Lordship. So apprehension is there, Your Lordship. Therefore,
I intend to peruse the case.
Not yes.
in the meantime, Your Lordship, I am seeking protection.
No protection.
But
After perusal of
not.
heard Mr. A.M. Khan, learned counsel for the petitioner, also heard Ms. S. Jahan, learned additional counsel. Considering the nature of allegation leveled against the present petitioner in the FIR, perusal of the case diary would be necessary for consideration of the instant bail application, hence call for the case diary.
Because there you have both the
11.
yes, Your Lordship.
Not
Not
required.
Okay, I
Not
think it-
required.
Not necessary. We will believe that you have filed second petition,
11, 12.
11, 12.
16,
May it please the Lord. My Lord, 438 application, FIR at case 11. There are 2 FIRs, Lordship, one filed by the informant and another filed by us, Lordship. And our FIR is at case 16, Lordship. My Lord, their allegation is that while the son of the informant was coming back from market, the petitioner dragged him to their house and snatched gold ring, mobile phone and money. Money is not mentioned, the amount is not mentioned. Lordship. And our allegation is that, Lordship, at page 16, the son of the informant followed the wife of the petitioner number 1, Texas, she was raped. While raping, the son of the informant was caught by the family members. He was handed over to the police. Police did not arrest him. He was let go. We lost the FIR, Lordship. We lost the FIR on the day itself, but that was not registered. After 3 days, the FIR was registered on 3rd of 11, Lordship. This is our case, Lordship. Lordship, initially, the FIR was filed by the informant was registered under available section. Lordship, may I kindly see case 12, the format. Page 12 on the top, it was registered under section 341, 352, 342. All are available sections. Similarly, Lordship, may kindly see page 15 also. Page 15. Received and registered Boku PS case number so and so under section 341, 352, 342. These are all available sections. Lordship, I don't know what
is 352?
3.
Lordship, 352 is punishment for assault or criminal force otherwise done on grave provocation.
So
It was bailable
Oh.
offense. Lordship, 394 is concerned.
why 394 was added?
After
Because
12 days, Lordship. It was added after 12 days, Lordship, from the registering of the FIR. পিছন, 12 দিন পিছন।
later on it was added 394. Voluntarily causing
what-
harm while committing
what-
property.
What is your submission?
My submission is that 394 is afterthought. Because initially the case was registered under bailable section.
No, afterthought by police,
Maybe, Lordship, I don't know what led them to brought this serious allegation
because
of
they found during investigation that there are materials under
Lordship.
394.
They may be influenced, there may be influence, Lordship. That part may be also there. Because our FIR was not registered at the moment when we lost. We lost the FIR on the 31st itself, on the day of occurrence. Next day, thereafter we approached, but our FIR was not registered. Their FIR registered on 2nd of November. Thereafter, our FIR was registered on 3rd of November. So, Lord, all these
Only-
things,
Though the
Their
ingredients
FIR is
of
a subsequent FIR.
maybe this is the reason, Lordship, I have stated.
311, Lordship, let us call for the case theory at this stage.
Oh, I have stated in my petition also, Lordship, may I kindly come to para 5 of my petition, Lordship. Lordship, may para 5, page 5 mechanism from 6th line, Lordship. May read a few lines, Lordship.
Okay.
Surprise-
Heard Mr. M.I. Hussain, learned counsel for the petitioner, also heard Ms. S.H. for other additional public prosecutor. This application under section 438 of the Code of Criminal Procedure, 1973 has been filed by the petitioners, namely 1, 2, 3, 4, 5. Name of the petitioner who are apprehending their arrest in connection with OPS case number 522/23 under section 341/352/342/394 of the Indian Penal Code. The gist of accusation against the present petitioners is that on 31/10/2023, one Robial Hussain had lodged an FIR before the officer in charge of Somtoli police station, inter alia, alleging that 5 numbers of accused persons named in the FIR, within bracket, the present petitioner, on 31/10/2023, at about 5:30 p.m. had assaulted the son of the son of the informant and confined him in a room and also snatched away money along with 2 golden rings and 1 well handset from him. Stop. Learned counsel for the petitioner has submitted that the allegations leveled against the present petitioner in the FIR are not true. In fact, on that day, the son of the first informant had committed rape on the
Wife of the petitioner number
wife of the petitioner number
1.
wife of the petitioner number 1, and he was caught red-handed by the petitioner number 1 by the family members of petitioner number 1. Thereafter, he was handed over to the police. However, police did not let him go.
Yes.
Police let him go. It is also submitted by learned counsel for the petitioner that on the same day, the wife of the petitioner number 1 lodged an FIR detailing the ordeal through which he had undergone. However, the police refused to register the FIR on that day, and it is only after 3 days the said FIR was registered. It is further submitted by learned counsel for the petitioner that though the FIR against the present petitioner were initially registered under section 341 slash 352 slash what are the sections? 342 of the Indian Penal Code. It is only after 12 days of the registering of the FIR, section 394 was added, which according to the submission made by learned counsel raises doubt on the conduct of the police as conduct of the police. Stop. Learned counsel for the petitioner has also submitted that the present petition against the present FIR against the FIR lodged against the present petitioner is a counterblast to the FIR lodged against the son of the informant by the wife of the petitioner number 1. It is further submitted that the petitioners are ready to cooperate in trial. Stop. On the other hand, learned additional public prosecutor submits that the perusal of the case diary would be necessary considering the allegations leveled against the petitioner in the FIR. Hence, call for the case diary fixing.
Lordship, on 13th,
Longer date.
long. Then in the month of
January.
January, 4th of January.
Fixing 4th of January for case diary. In the meanwhile, considering the facts as revealed from the materials on record, as well as considering the submissions made by learned counsel for the petitioner, the petitioners, namely so and so 1, 2, 3, 4, 5, are hereby directed to appear before the investigating officer of BOCO PS case number 522/2023 and within a period of 10 days from the date of this order and cooperate in the investigation. So if they do so within the stipulated period of time, they shall be allowed to go on interim bail of rupees 30,000 each with one surety of like amount, subject to the satisfaction of the arresting authority, with following condition that they shall cooperate in the investigation.
My lord, whether the CD for the FIR filed by us will be declared
Not the
not obliged, highly obliged.
second condition that they shall not directly or indirectly make any inducement, threat, or promise to any person who is acquainted with the facts of the case. The complete.
Highly obliged.
Let this case be listed again on
No,
4th of
4th of
January.
January.
17,
Vijay,
It's
he has
17
this
and
condition
18
from
same
there is a
effect.
format. Yes,
17 and 18 same effect. Two petitioners. The allegation against the petitioner is this: the informant daughter committed suicide due to mental torture of this petitioner. Before she committed suicide, she lost two persons. These two petitioners lost. Both are the proposed for marriage.
both are the petitioner before this court.
Plus one item number 18 and another item number 17. Prohibited. This is the allegation. Alright, nothing any physical torture. Both are want to appear before IO.
Yes, Ms. Bora.
Lordship,
There is a suicide note also.
Lordship,
Suicide note is there.
yes,
Yes.
Lordship.
Therefore, they were appear want to before IO.
No, let us go through the case there
Lordship,
because suicide note is there.
yes.
What is there in
Let's hear this.
As per suicide note, she has taken decision of on account of mental torture given to her by these two persons.
That is the
where is the suicide note?
FIR page
Suicide note,
last suicide note is not available.
No, whether you have named
Lordship, that is not before us.
suicide
because-
note, we will go through only in the case that
Yes, it's a part of the.
This is father. This father
This is
lost the
allegation, Lordship.
father lost the FIR.
no, what is the submission?
Lordship, may I call for the case diary, Lordship?
Case diary would be required.
Allow me to appear before IO.
Not
think-
now, after perusal of the case. Third, Mr. L. Gogoi, learned counsel for the petitioner, also heard Ms. S.H. Bora that the petitioner for the prosecution. Perusal of the case diary would be necessary considering the nature of allegations leveled in the FIR. Hence, call for the case diary fixing.
Lordship, 1912, then 1812.
Fixing 1812 for case diary in both cases, 17 and 18.
Lordship,
item 19,
Well, this petitioner is requesting your lordship, my lord, for the third time with respect to the, my lord, third case. My lord, the earlier.
Third time or third case?
Third case.
First two time?
First two time, my lord, interim has been granted in two different cases. Now,
So
while
this is not third time, this is first time.
this is first time for the third case.
Okay.
But pursuant to those, my lord, the interim orders, well, I proceeded to, my lord, appear before the court, and I came to know, my lord, that another case is there, my lord. But as my lord, the facts your lordship could recollect, my lord, that he has resigned from the post of, my lord, CEO of that, my lord, bank, Mahabharata, my lord, Union Bank, my lord, Urban Bank Limited.
This case is filed by whom?
By the same informant of the, my lord, first case, my lord, that present Probin Kumar Lahore, my lord, who is present CEO. My lord. First FIR, he
What is the allegation?
my lord, this time direct allegation is that, my lord, I have, my lord, lordship will kindly find, my lord, the FIR is at page 41. Lordship may come to page 46, that is the vernacular. The translation is not very appropriate. Forty-six.
46.
46 is the vernacular. Translation is not very proper, so therefore I'm taking a lot of space. The cause of action is the same, my lord, that the Reserve Bank had, my lord, a scrutiny after scrutiny. Now here the period has been given, my lord, 1914 to 2023. May I read?
Yes.
Purvak Nibedan is a
When you have resigned,
my lord, I have resigned in 2020. And I have handed over chairs to the present CEO who was at that time accountant. Now in the first FIR, he said it is one, my lord, not of the department who has misappropriated about some lakhs of rupees, my lord, to his own account. And now after a few days, this has been, my lord, lodged, saying that it is me, my lord, who have nearly, my lord, the amount has been given a pretty, my lord, big, my lord,
yes,
price due equity, my lord.
Allegation of near about 2 crores.
please read.
সন্মানপূৰ্বক নিবেদন এই যে নিম্নলিখিত ব্যক্তিজন মহাভৈৰৱ কোঅপাৰেটিভ আৰবান বেংকৰ মুখ্য কাৰ্যবাহী বিষয়াৰূপে বহু বছৰ চাকৰি কৰি আছিল আৰু যোৱা 2020 চনত স্বাস্থ্যজনিত কাৰণ দেখুৱাই চাকৰিৰ পৰা তেখেতে অব্যাহতি লয়। অব্যাহতি লোৱাৰ সময়ত তেখেতৰ বেংকৰ লগত কোনো টকা পইচা লেনদেন নাই বুলি দৃঢ়তাৰে কোৱাত তেখেতৰ কথাকে বিশ্বাস কৰি সঞ্চালক মণ্ডলীয়ে তেওঁক চাকৰিৰ পৰা অব্যাহতি দিয়ে। কিন্তু যোৱা 1914 চনৰ পৰা 2023 চনলৈ RBI হিচাপ পৰীক্ষকে পুনৰ নিৰীক্ষণ কৰি দিয়া ভাষা মতে বৰ্তমান এই কথা পোহৰলৈ আহিছে যে শ্ৰী ৰঞ্জন শৰ্মাই অতি চতুৰালি কৰি মহাভৈৰৱ কোঅপাৰেটিভ আৰবান বেংকৰ প্ৰায় 2 কোটিৰ অধিক টকা আত্মসাৎ কৰি বেংকৰ প্ৰতিষ্ঠানটোক বহুত বিপদত পেলাইছে। বৰ্তমান এই কথা পোহৰলৈ আহিছে যে তেখেতৰ কাৰ্যকালত তেখেতৰ পৰিয়ালৰ কিছুমান ব্যক্তি মিছা নামত নিজৰ পত্নী আৰু ভনীয়েকৰ নামত একাউণ্ট ব্যৱহাৰ কৰি বেংকৰ পৰা উক্ত ধনখিনি উলিয়াই লয়। শ্ৰী ৰঞ্জন শৰ্মাই অতি চতুৰাতিৰে এই বেংকৰ ৰাজহুৱা ধন অপব্যৱহাৰ কৰি আত্মসাৎ কৰাৰ প্ৰমাণ পোৱা গৈছে।
Now this is direct allegation.
Direct allegation. The first one, your lordship will kindly see, my lord, at page 21. Same person, same, my lord, things, my lord, page 21. I beg to inform you that from the data obtained from the investigation carried out by the auditor of the Reserve Bank of India with effect from 18/9/2023 to 23/9/2023 in the Mahabhairav Cooperative Urban Bank, and from the statement received from the State Bank of India Tezpur main branch, it has been found with proof that the bank auditor cum IT officer Sri Dipanjyoti Nath, son of Sri so-and-so, permanent address so-and-so, care of Sanjit Kumar Kolita, Ketekibari, Sonitpur, Tezpur, Assam, mobile number so-and-so, has misappropriated approximately 34 lakhs by transferring the said money to his own account maintained in different bank, and also mishandle important bank documents. The same Reserve Bank, my lord, scrutiny, same thing.
No, but this first allegation was against an accountant,
Lodge.
against a specific amount,
Lodge.
34 lakh.
34.
But this time it is directly pointing towards you,
Lodge.
again a specific amount.
Lodge.
So these two are different affairs.
My lord, with respect, my lord, the whole cause of action that has arisen, the things has come up from the Reserve Bank, my lord, the scrutiny of the, my lord, bank account from 1913 to 2023. Now, at the first FIR, it has been said, my lord, that they depend on about 34 lakhs.
Only
Then, my lord,
34 lakh.
34 lakhs. Then again, if your lordship recollect, the another FIR by the, my lord, this Tezpur Bar Association is also there, but for time being, my lord, will not go into that. And the second one, my lord, it says that the same scrutiny, pursuant to the same scrutiny by the Reserve Bank, my lord, another, my lord, 2 crores and odd, my lord, has been, my lord, misappropriated by me. It is the, my lord, the
sequence of events, my lord, leading to the same, my lord, incident of, my lord, Reserve Bank of India scrutiny, my lord. The police is, my lord, definitely, my lord, this will be a subsequent information for the, my lord, for the, my lord, investigating agency to, my lord, investigate. That is another thing, my lord. But it cannot be a, my lord, a separate affair just because the person's name is different and the amount is different. In that way, my lord, series of acts will, my lord, come, my lord. If your lordship takes into the ratio laid down in the, my lord, T.T. Anthony case as well as the Amit Shah case, my lord, where, my lord, in the T.T. Anthony, if your lordship recollects,
What?
my lord, yes, my lord, the second, my lord, first, my lord, the facts in T.T. Anthony case was such, my lord, there was a, my lord, two incidents had taken place under one police station at a different place, and 2 FIR had been lodged. But then, my lord, the court has that it was because of the, my lord, this mob, the same mob. One incident had taken place, another incident had taken place. It is a series of act of the mob. So therefore, the second FIR lodging is, my lord, cannot be, my lord, raised. It will be a subsequent, my lord.
But this is a different.
So here also your lordship will say 1913 to, my lord, 2023, my lord, the Reserve Bank is scrutiny. At different period, my lord, they'll go on. Now, my lord, so far as the information out of the same thing, they are saying that this Deep Jyoti Nath has misappropriated 23 lakhs and so, and I have, my lord, misappropriated, my lord, 2 crores. Let us, my lord, go by the, my lord, what it has been said. So these are the same scrutiny, my lord, same misappropriation at different time. There may be, my lord, another 10%.
How same in a bank, in a banking institution,
Same place.
there may be misappropriation several times by several persons.
Yes.
Yes, my lord,
Because
here,
daily monetary transaction happen.
now, my lord,
So
why, yes,
here the specific allegation against you is that you misappropriated 2 crore during this period
during,
against Deep Jyoti Nath.
so, my lord, which
34.
period that has not been said, my lord, what he has said, my lord, that my devoter, I have, my lord, very, my lord, assertively said that nothing, there is nothing wrong with the, my lord, banking transactions, so you accept my resignation, and the board of director has accepted. That is in 2020. Now, my lord, 2020, my lord, 3 is going on, my lord, and I have, my lord, handed over just to the present, the CEO, my lord, who has lost this, my lord, FIR. He was at that time account, but he was, my lord, very much aware, my lord, all these things, man. It is only, my lord, only to, my lord, malign my image and, my lord, they divert the whole thing to me, my lord, because if you lord again come to the, my lord, Facebook Bar Association FIR, that also I have lodged, my lord. There the advocate have said the employees as well as the, my lord, members of the board of directors. So the whole, my lord, thing goes to the present CEO. Now he is to explain at different times. And even, my lord, it goes, my lord, this particular person was the accountant at the time when I had, my lord, resigned. And subsequent, my lord, 3 years have passed, my lord, it is the blame goes to him, my lord. He is to explain. And all these things, my lord, apart from all these things, these are matters of record. I have resigned, my lord. Whatever is there, my lord, it's a documentary evidence, my lord. And in the other 2 cases, lordship has, my lord, considering this, my lord, period of date of resignation, and, my lord, considering the allegation therein, my lord, lordship has granted, my lord, interim protection till, my lord, 20th, and direction was there to, my lord, for me to appear, my lord.
We appeared.
My lord, when I went to, my lord, appear, my lord, this 3rd case came out, my lord. So tomorrow is the last date, my lord, I have to appear somehow, my lord. Tomorrow is the last date.
Yeah. Now, what is your sub?
My lord, my submission since 2 cases of the same transaction has been given, my lord.
It is not same
Yes.
transaction. It is in the same bank. It was detected by an RBI audit,
Yes.
but against different person. Allegations are made against different person. In one FIR, allegations was made against Deep Jyoti Nath,
Yes.
and in this FIR, specific allegations are made against.
Schedule to record.
My lord, even, my lord, if your lordship takes up the Anil Shah case also, my lord, there, my lord, the
That is a mob case.
no, that was in TT and 20, my lord, this Amit Shah case, that death of Sahabuddin, my lord. The first case was registered against death of Sahabuddin. Then subsequently, pursuant to the Supreme Court direction, my lord, the CBI investigation found that the police personnel are involved, my lord, in my lord, murdering one of the, my lord, witnesses. star witnesses who witnessed the the Sahabuddin's murder. So CBI has registered a separate case. Supreme Court says no, it is in the same transaction. Maybe at two different times, two different.
Here, one thing may help.
At this stage, without going into all
That the same informant had lost FIR earlier
Yes.
when the facts were known to him. Same info, and when he got interim bail, he again had lost the FIR subsequent. This may be a factor because the earlier FIR was lost on 4th of October.
But this was also prior to grant of the interim order. But it was not known to me.
1910.
Since the series of same things and the entire documents are with the bank, I have resigned. I cannot influence any of the persons. And two cases that they are on 20th.
At this stage, I'll insist on calling for the city. Because
The
it is a
Regarding his prayer for interim,
Lordship, not at this.
Mr. Vishas, you are somebody.
Telephonically, I have been asked by the bank, the bar association of Tejpur. I
But
became,
bar association is not the.
no, but because we have lodged a file.
We are the shareholder.
We are not only shareholder, I was once of the director of this bank. It was our effort, his father. It was 107 years old bank. The allied person of Tezpur has done this bank, my lord. It is one of the noted in cooperative bank of Assam. And that this boy for whom bail is, we have appointed him 500 rupees salary. Later he drawn 12,000 rupees salary.
After painstaking effort.
Now 16 cars he is having. 16 cars.
Whenever I was in by that bar.
No, you formally appear.
Then just we have been informed, my lord. That
Yes, I came to know, my
that's why we came to know, my lord. We do not know. I will file in a formal now, my lord. Let it come other day, my lord. In the meantime, my lord, CD may be called for without interim, my lord.
In the case which they
Yeah,
have filed
All
the
shareholder.
in which they have filed the FIR, Lordship has considered and granted interim bail.
We have got strong
They can
objection.
come always for modification or objection at that time.
No,
of
no,
hearing.
no.
For that is a different.
9 crores already siphoned. 9 crores. Okay.
At this stage, I'm
He also
opposing the
he
interim.
himself
Your
has said he
Lordship.
also.
From my
they have
account
to-
also it got more than 1 lakh. Because my account is there.
Actually, my father,
Yes.
he had his contribution, my lord, and his painstaking effort, the bank came. to
No,
that
no.
kind of
Now
stage.
at this stage, I am concerned.
The corpus money that was
On
not
20th,
initially
everything
deposited.
can be sorted
So
out.
the
CD
effort of
will
the
be
all,
coming,
my
my
lord,
lord.
can
Till
be
then, my
there.
protection, my
Yes,
statement will be there, my lord, before.
The money was
before them.
collected and corpus money was created.
You are
After
given
that, with the
interim
information from the Reserve Bank
In
was
both
Hey.
the cases,
till 20th
Lordship,
on other two cases.
on other two cases. Both the cases orders I have, my lord, annexed. And the direction was there to appear, my lord, and keep my state.
He has a case for interim. Let him appear before IO. And you formally appear in this case and file your objection. Then we will
Let
hear
it come
you.
near that day, my lord. We will file it.
No, we'll hear you on.
Monday we will file, my lord. But if your lordship grant him interim, my lord,
It
he
will be
is a
case.
very intelligent boy, my lord. We know him. We have brought him, my lord. And we have seen how he has done.
Since long we are.
Lordship, at this stage, I'm opposing the interim.
My lord, he himself saying that he is one of the director and.
Once I was the director, once, not now.
And the
It
bar.
was our effort, my lord. Bank got the
And-
recognition from Reserve Bank of India.
And the bar association puts a allegation, the members
21
of the
lakhs bar
board of
association,
directors
21
are also
lakhs.
involved.
Present director,
Present director.
not against the past director. My father was also director
Director.
at that
No,
time.
if something is found against him, interim can always be cancelled.
Yes,
Interim
that's
is
true,
not
madam.
an absolute liberty. If materials are found against him in the case diary, then it may be cancelled. You may appear.
That's possible, my lord. Even there are lots of money is involved in this case.
The public money is involved. People are not getting any money, my lord. Our
Now,
bank is closed.
All functions.
Our function is closed.
I am not hearing both of you unless you appear formally.
My lord, your lordship has definitely seen the bank, Mahavira Cooperative Bank, very near by our court.
No,
complex.
now the question is, as he is an interim in two cases, and
No, but the gravity of all the cases are not same.
he's a retired person.
Retired, he retired when he got the sense that something will go happen. So he resigned. Man. We have
Now,
accepted.
as an officer of court, I am asking you, not as counsel in this case, because you have yet to appear formally.
Yes.
So you can always assist as an officer of the court.
Yes, madam.
what do you apprehend? Whether he will plea away or whether he will
He may flee away because it is a charge of 9 crores.
we will impose conditions
Appear my within that's
With some
tomorrow is the
observations.
last date in attack.
or till 20th. What do you apprehend?
No, we want that he
should be jail.
he should be interrogated. Custodial interrogation is very much required. That type of case.
Let us see the observation of the IO, what CD says.
Otherwise,
Because-
at this stage, I'm opposing the bill.
Tezpur bar, Tezpur people sentiment, my lord.
You can always represent Tejpur Bar in that case on 20th. In this case also you can appear.
Because our money is involved, my lord. We can come. Formal occasion will come.
Formally appear for vote, sir.
And we are going to file a PIL also, my lord. We are going to file a PIL.
Heard Mr. P. Jesoikia, learned counsel for the petition, learned senior counsel for the petitioner assisted by K. Barua. Learned counsel for the petitioner. Also heard Ms. S. H. Bora, learned additional public prosecutor. This application under section 438 of the Code of Criminal Procedure, 1973, has been filed by the petitioner, namely Shri Ranjan Kumar Sharma, who is apprehending his arrest in connection with Tejpur PS case number 871. This is third case, 871/2023.
No, this is 894, my lord.
This is 871.
871. Under section 409/420 of the Indian Penal Code. Stop. The gist of accusation against the present petitioner in this case is that, where is the affair, present affair?
Lordship, we are at page 46.
That on 19/10/2023, one Shri Probin Lohkar, Chief Executive Officer of Mahabhairav Cooperative Urban Bank Limited, Tejpur, had lodged an FIR before the officer in charge of Tejpur Sadar Police Station, inter alia, alleging that the present petitioner was serving as the Chief Executive Officer of Mahabhairav Cooperative Urban Bank for many years, and in the year 2020, he took retirement from the service on the ground of health related issue. It is stated in the FIR that at the time of taking retirement from the service, the board of director allowed him to be released from the service on good faith, on the basis of the declaration made by him that no monetary transaction is pending against him in the said bank. However, it is alleged in the FIR that after the audit conducted by Reserve Bank of India from the period 2014 to 2023, it was found that the present petitioner has it cannot be found in audit, that present petition.
সঞ্চালক মণ্ডলীয়ে কিন্তু যোৱা 1914 চনৰ পৰা 2023 চনলৈ RBI হিচাপৰ পৰীক্ষা পুনৰ নিৰীক্ষণ কৰি দিয়া মতে বৰ্তমান এই কথা পোহৰলৈ আহিছে।
It has come to the light that the present petitioner has misappropriated about 2 crores from the Mahabhairav Cooperative Urban Bank while he was the chief executive, while he was working in the state bank. It is also alleged that he used the account of some fake, he used account under some fake names of his family member and transferred the bank's money to the state account. Stop. It is submitted by learned counsel for the petitioner that the allegations leveled against the present petitioner in the FIR are not true. It is further submitted by learned counsel for the petitioner that the same informant who had lodged the present FIR had earlier on 4/10/2023 had lodged another FIR against one Deep Jyoti Nath alleging misappropriation of money from the Mahabhairav Cooperative Urban Bank. And at that time, no allegations was leveled against Mr. Sakya.
Sir.
In the earlier
No
FIR,
allegation.
at that time, no allegations was leveled against the present petitioner. Stop. It is further submitted by learned counsel for the petitioner that in the earlier FIR lodged by the present petition, lodged by the same informant against one another accused, the petitioner was granted interim anticipatory bail, and the next date of the state case is fixed on 20th of December. It is further submitted by learned counsel for the petitioner that in another case lodged against the present petitioner by Tejpur Bar Association over the same matter, he has been granted interim anticipatory bail by this court in, where is the,
Well, is it Tejpur Bar Association at page 23, the order. I'm sorry.
page?
Page 37.
What was the last?
This Tejpur Bar Association that has been filed. PS case number 894 of 2023.
Wherein he has also been allowed to go on interim anticipatory bail, fixing the said date on
8/9.
the said case on 20th of December. Learned counsel for the petitioner has submitted that as this FIR has been lodged out of the same transaction, the same transaction. What is your submission?
It should have been taken as a supplementary information to the first FIR.
3943.
The
Case number is
and as the same is based on the audit report of the RBI, it could have been taken as a supplementary information in relation to the FIR which were already filed in connection with the state bank. Stop. On the learned counsel for the petitioner submits that in the earlier case, the petitioner has been allowed time for 10 days to appear before the IO investigating officer, which would lapse on tomorrow, tomorrow. And therefore, he prays for an interim protection so that he may appear before the investigating officer. On the other hand, learned additional public prosecutor has opposed the grant of interim bail on the ground that the allegations of huge sum of amount, misappropriation of huge sum amount has been made specifically against the present petitioner, and considering the nature of allegation, the prayer for considering the nature of allegation, he submits that perusal of the case diary would be necessary before for consideration of the instant and prepared application. So, Mr. S.C. Bisar, learned counsel, has appeared and submitted that he would be appearing for no, that you once said that you are appearing for the informant bank manager.
Yes. Not bank manager, but Tezpur Bar Association.
But Tezpur Bar Association is not the party.
Then I'm not a bank manager because they have not told me. The Bar Association told me.
Then you have to appear in that case. In the other
I will appear. I was under the presumption this is the case by Bar.
Then I am not showing both of your names.
Yes,
Mr. Mohan.
did not require. We will come forward.
Perusal of the case diary would be necessary for consideration of the instant bail application. It's called for the case. However, considering the fact that in similar matter, the petitioner has already been granted interim protection in 2 other cases, namely in
Tezpur PS case number
Tezpur
815 of 2023.
Namely Tezpur PS case number
815 of 2023
and
Tezpur PS case number 894 of 2023.
stop and as the matter involved in this present case is similar to the allegations made in the above noted cases, and as the interim protection has already been granted to the present petitioner in those cases, this court is of considered opinion that till perusal of the case diary by this court, the petitioner is entitled to get interim protection. Hence, the petitioner, namely Ranjan Kumar Sharma, is hereby directed to appear before the investigating officer of Tezpur PS case number 871/2023 within a period of 10 days from the date of this order and cooperate in the investigation. If he does so within the stipulated period of time, he shall be allowed to go on interim bail of rupees 30,000 with one surety of like amount, subject to following conditions: that the petitioner shall not leave the jurisdiction of the, where do you stay?
Tezpur Government he stay. I know he's
Sonitpur district
Shall not leave the jurisdiction of Sonitpur district.
and also Kamrup, because he may have to.
Therefore, I am asking, what is the area within which shall not leave the state of Assam?
Yes.
State of Assam without prior permission of the Chief Judicial Magistrate Sonitpur and prior intimation to the investigating officer of the Tezpur PS case number 871/2023 until further order. The next number 2, the petitioner shall not directly or indirectly make any inducement, threat or promise to any person who may be acquainted with the facts of the case so as to dissuade such person from disclosing such fact for the investigating officer or before the court, before any police officer. Let this case be listed along with BA application number.
AP number.
Let it come together.
AB number 3940
AB number 3940 and
23 and AB number 3958 2020.
and AB number 3958 2023 on 20th of December.
Lordship, subject to correction. Lordship, in that earlier two cases, he was not the FIR named accused person. But here
In
in
one
this,
case, he was named.
yes,
In Tezpur Bar Association
yes,
case,
but
he was
in one of the cases, Lordship, he was not named. One deputy, not he was
Yes.
named, Lordship. So
the-
here in this case, he was specifically
he
named.
is the only FIR name. We will see on 20th
Lordship,
after
Lordship, otherwise.
perusal of the case there.
I'm
Because
authorized.
this will be contested matter.
Yes.
Seems to be highly,
Well, only one, well, they may not lodge any FIR now, my lord, again.
Who?
You.
Tezpur bar is lodged.
there is no,
Individually, they have not.
Not a fair we have lost. We will do something definitely.
no, Mr. Vishwas was former director of
Yes,
this
that's
bank.
what-
Yes, I was the director. My lord,
So-
how many times I came to the Reserve Bank, I know.
In the Tezpur
So
bar,
you may have to come again.
Lodge, that's what, my lord, if a direction be issued not to lodge any FIR.
No, no. We'll see how to,
Yes.
public's money, if they are whipping money, they cannot get the
We'll
money.
see on
Authorized.
20th.
Obliged.
Item 20,
May I please? My lord, this is for 38 application, my lord. FIR is page number 9. My lord, FIR is very much specific. FIR was lost against my lord 3%. Page number 9, my lord. May I read, my lord?
Okay, FIR was against 3%. There are
Ahanur Islam, Suleiman Ali, and Monwar Hussain. I am not FIR named accused person, my lord.
Why are you apprehending your arrest?
My lord, on the date of occurrence, I was at Arunachal Pradesh, my lord, but somehow the investigation agency apprehending me, and in this regard, I applied for anticipatory bail before the Honorable District and Session Judge Amin Gao, and the Honorable District and Session Judge Amin Gao granted aid interim period bail, and after getting aid interim period bail, I appeared before the IO, my lord. Kindly for a moment, page number 17 onwards, my lord.
Okay, then thereafter what happened?
Thereafter, my lord, Honorable District and Session Judge rejected my prayer, my lord,
After
holding that
perusing,
sufficient materials are available against 2 persons who are not apparently accused. My lord, kindly for a moment, page number 17, my lord. As because the petitioner filed objection against the IO, my lord. May be taken in otherwise, my lord. May I read, my lord, page number 17?
no, but your bail was not made absolute by the district, by the session judge.
My lord.
After
Holding that-
perusal of the case there.
My lord, that diary was up to 24/10/2011. I got interim bail on dated 1/11/2023. I appeared before the IO on 3/11/23, my lord, but my statement was not available in the record, my lord. Kindly for a moment, my lord, page number, my lord, 19, my lord. This is a bail application filed under section 438 CRPC paying for allowing the accused petitioner Ibrahim Ali to go on clearance bail in connection with.
No, you come directly to the point.
My lord, my lord. Third para, my lord.
Because we intend to call for the case there.
Yes.
Because it was not made absolute. Once you were given.
My lord, I have appeared before the IO, my lord. I have been interrogated. Whether further custodial detention is necessary, my lord.
Then why?
Because if the FIR is true, my lord, then 3 persons committed the offense, my lord. Other persons not committed the offense, my lord.
Why the bail was rejected?
My lord, fourth para, my lord. I have considered the report submitted by IO. I have carefully perused the CD furnished by the IO. Perusal of the CD reflects that the IO during the course of investigation harassed 2 of the FIR named accused Anticipatory Islam and Suleiman Ali. Perusal of the CD further reflects the IO during the course of investigation has recorded the statement of complainant and also recorded the statement of injured victim. Perusal of the statement of the injured victim reflects prima facie materials against the accused petitioner Ibrahim Ali and Osman Goni.
What is your name?
Ibrahim Ali. My lord, kindly for a moment, my lord, FIR, my lord.
No, FIR, it may not be there.
My lord, the victim clearly stated that he has snatched away the key of the motorcycle of the above noted 3 persons, my lord. Our number reflected by the victim as well as the informant, my lord. FIR is very much clear, my lord. The victim snatched away the key of the motorcycle from this above 3 persons, my lord.
Okay.
How it is possible other persons entry, my lord? This is my lord, horrifying, my lord.
No.
Page number 9, my lord.
That is
May I
not the
read the FIR, my lord? My
encyclopedia,
lord,
Lord.
kindly for a moment FIR, my lord. Last
No,
part, my lord.
Mr. Parvanik, I
My
have
lord.
understood.
My lord.
You are not named in the FIR.
FIR, my lord.
3 other persons are specifically named in
My
the
lord.
FIR. But however, after perusal of the case diary,
My lord.
session judge has observed that there are material against you.
Yes, sir.
Therefore, we have to peruse the case.
Yes.
In
That
that,
is
my lord,
this much.
kindly call for the diary, my lord, as because I have already appeared before the IO. IO interrogated me, but not released on bail me, my lord. That is the technical problem, my lord. Clearly, my lord, page number 19, my lord. Page number 19, my lord.
Mr. Baku PS Lordship may give us a sort.
My lord, kindly page para 3, my lord. My lord, just for a minute, page number 19.
Now, whether IO has again trying to arrest you.
No, my lord, not arrested.
Then why is there?
Not arrested. My lord, it will come clear, my lord. On 16/11/23, IO had furnished the CD.
No,
However,
Mr.
CD was,
Parvani,
my lord,
you answer my query.
my lord,
Once you are released on bail,
not released on bail. I
Once-
have interrogated.
once you have been interrogated,
My lord,
whether IO is again trying to arrest you.
my lord,
Now.
of course, my lord, apprehending in my home, my lord. That is why I have come here only. My lord, I will appear before the IO.
No, but,
Let my statement to become, my lord.
but in view of the judicial order passed,
Yes,
My lord, that
after perusing
my
the
lord,
case,
but
there is sufficient
the
evidence
diary
has
was
been
not
found
updated.
against you,
Diary
Lordship.
was up to 24/10, my lord. I have appeared on 3rd/11, my lord.
So everything will be revealed from the case diary, Lordship. Let us.
when have you appeared?
My lord, I have appeared on 3rd/11, my lord.
3/11.
3/11.
But the rejection order was passed on 22/11.
22/11. But the diary was, my lord, up to 24/10, my lord. Kindly
That
for
we
a
do
minute.
not know at this stage, Lordship.
My lord,
Yes.
perusal of the CD, my page number 17, perusal of the CD.
Let us take a short dip.
My
Lordship.
lord, that is, my lord, kindly for a moment, my lord. Perusal of the page number 17, perusal of the CD reflect that CD is ready up to 24/10/23. CD reflects that the IO has received the copy of the order dated 1/11/23 passed by this court. However, CD is silent after 24/10/23 as to whether the accused Ibrahim Ali had appeared before the IO or not as per order dated 1/11/23. On the other hand, the accused petitioner by filing petition number such and such has specifically stated that after the order dated 1/11/23, the accused had appeared before the IO, but the IO has misbehaved him and questioned the authority and propriety of the order passed by this court. My lord, next page, my lord. In view of the above, the IO is directed to submit a report as to whether the accused petitioner Ibrahim Ali appeared before the IO after passing the order dated such and such by this court. Report of the IO should be reached this court on before 22/11, and the CD be kept with the record. CD was kept with the record, which was updated up to 24/10/23, my lord. My statement not available in the CD, my lord. That's why, my lord, CD may of course nationally call for the CD, my lord, but till then, my lord, I may be allowed to go on interim bail as because earlier once I have appeared, I also again appeared before the IO, my lord, will appear before the IO, my lord.
From the order of the lower court, Lordship, it is reflects that the interrogation of the accused person is highly required.
I have admitted that. I have appeared as because
So Lordship may
three
kindly fix a
FIR
short
is
dates.
against
We can
FIR
produce
is
the case
against
diary.
3 person, my lord.
Thereafter,
where
Lordship may consider his interim.
from whom the victim snatched away the key of the motorcycle, my lord. Is it possible? Other person's presence, my lord. Incident on 17/10, FIR lost on 18/10, my lord. After one day lost the FIR, my lord. Whether the informant committed mistake, my lord.
Heard Mr. A. Paramanik, learned counsel for the petitioner. Also heard Ms. S. Jahan, S. H. Bora, learned additional public prosecutor. this application under section 438 of the Code of Criminal Procedure, 1973, has been filed by the petitioner, namely Ibrahim Ali, who is apprehending his arrest in connection with Boko PS case number 496/2023. The accusation against the present accusation in this case is that on 18/10/2023, one Muhammad Shafiqul Haq had lodged an FIR naming three persons, naming three accused in the said FIR, namely Muhammad Shahanur Islam, Muhammad Suleiman Ali, and Muhammad Manwar Hussain, inter alia, alleging that on the previous day, that is on 17/10/2023, when the brother of the first informant, Rashidul Haq, was proceeding to his home, the FIR named accused person assaulted him and took away rupees 3 lakhs, which he was carrying at that point of time. No, FIR is lodged by the brother of the
victim, my lord.
victim may
Shafiqul
be
Islam.
knowing. So merely FIR is not naming you,
Yes,
does
the
not
victim
mean,
has implicated.
but
My lord, victim snatched away the key of the motorcycle of the accused person who came in a motorcycle. Victim snatched away.
it is also alleged in the FIR. It is also alleged in the FIR. No, perusal of the case. I repeat.
No, my lord, till then, my lord. As
No.
because I have appeared before the IO, I have been interrogated, my lord. But my statement was not available in
Then
that
12, lordship.
in that CD. My statement was not available, my lord. CD was up to 24/10, my lord.
Let it be updated, lordship.
My prayer has been rejected on 22/11, my lord. So my statement was not
If it is not,
available.
if it is not recorded, then he may file an additional affidavit that the IO has refused.
I
to
have filed
record his
objection before
statement,
the
lordship.
learned district and session judge, my lord. I have already filed objection that my statement was recorded. Rather misbehaved me, my lord.
It has to become on record, lordship.
Yes, available in the order
It
dated
is
16/11, my
it is
lord.
further alleged that, and it is also stated in the FIR that the younger brother of the first informant snatched away the keys of the motorcycle of the accused person, and thereafter accused left the motorcycle and ran away therefrom. Stop. Learned counsel for the petitioner has submitted that the petitioner had approached learned session judge Kamrup Amingaon by filing an anticipatory bail application which was registered as AB number 695/2023, in which he was earlier allowed to go on interim bail by the learned, in which he was allowed to go on interim bail. It is further submitted by the learned counsel for the petitioner that though in pursuant to the directions of learned sessions judge Amingaon, the petitioner had appeared before the investigating officer. However, he was not arrested at that point of time and he was not
Released on bail. I was not released on bail. I have been interrogated but not released on bail.
if you are not arrested then your everything goes.
No, my lord, it is available in the order dated, my lord, 22/11. This is not my submission, but it is in the available in the
When
order dated
is
23/11.
12.
Kindly for my lord,
12 case diary. I will complete the order in cap.
my lord, kindly I may be allowed to go on interim bail.
If I, after going.
My humble submission, kindly peruse the order dated 16/11 and 22/11, which is elaborately mentioned by Honorable District and Session Judge. He was not allowed me on bail. I have put objection
Okay.
against the.
Okay, I have heard you. If I feel that interim would be necessary, you will be granted interim, otherwise not.
My lord, I have filed a specific objection against the IO. I have filed a specific
That I have-
objection against the IO.
that I have-
That's why Honorable District and Session Judge reflected all the submission of my submission.
Yes.
My lord, kindly page number 70 to 20. Kindly,
Okay, I will go through it.
my lord.
May I please?
30 already considered to the court information from Pradesh CP. So petitioner is behind the bar. Section 302. Behind the bar.
No, before that, as regards other leftover matters.
My lord, item number, sorry.
Item number 27 is an appeal against the judgment convicting the appellant. And there is an application for consideration of the bail.
Bail.
I say that your lordship may leave the appeal and fix a date for consideration of the for bail. It's an appeal against the judgment.
Okay, I'll pass that out.
Yeah,
After
and
2
also
weeks.
2 weeks for consideration of bail.
Okay, after 2.
Right.
Item 27.
My lord,
Item 49. Met.
Item 41, lordship. I made a mention before, Honorable Justice Arundev Chaudhary, as because lordship, there is a direction to pay an amount of the awarded amount, item number 64, lordship. The order for the
Production method, lordship.
64, lord. Maintenance awarded to the ex parte order was there, my lord. Subject to continuation of that order from that month, lordship, the coercive action shall not be passed, lordship. They are taken up. That order has been passed by the court. But when he appeared before the court, lordship, to deposit the amount, lordship, before the court, court refused to receive the amount because, lordship, he asked him, down a learned court asked him to pay more amount, what is dictated in the order sheet, lordship. For that reason, a reasonable or
That means High Court order was not complied with.
not compliant. That is your lordship. Date is fixed on 12th of December, lordship.
We'll take it up on Monday, Tuesday, because record has to be gone.
Lordship, only my humble prayer before your lordship, from the current month that should be there, because he's a poor person, and I made a mention, and the this
Not like that. I have to understand what.
if lordship permits, then that may be taken up today if possible, lordship.
Today, nothing is perfect.
That for that only one word, for only work correction of one word.
This may be taken up as an first item on the next available day within time. I can take it up on next Monday, on Monday as first item if you have short matter.
Only for that, lordship,
Okay.
because there is an order from the court, lordship.
Item number
64.
on request of S. Nargis. Let this matter be listed. This is under which column?
Orders column.
Let this matter be listed on 4th of December to be taken up as a first item after motion matter. Is it okay?
And I,
As motion or
After
after
motion,
motion, as
in-
first.
as first item, whichever, it will come up in order column, but it will be called up as first item after. Yes, you are.
Order to- Oblige, lordship.
item number 49, my lord,
No,
is
let-
pending since 2019. It's a criminal appeal matter, so matter may kindly be taken up next week.
No,
And
therefore I am suggesting Court master will address all your concern. He will give accommodative dates. You, wherever there is an interim would continue. Otherwise, you have to pray for the year Islam.
Small prayer lordship or correction lordship. Cost item. Small prayer. Then dispose matter. Production matter actually.
Correction in
The cost list. Cost title.
in the order.
Other's name is not. Small prayer.
Cost title in your
Yes, the order and
in
the
the order passed by this court. Okay,
Yes,
this I will do in chamber. If there is an error by this court, this I will do it.
by this court.
Okay. Race matter,
Item 21, my lord, this matter of 2018, my lord.
you have not understood why I have.
Lordship, item number 7 may be taken up on Monday.
Again, court master, same, it is a covered matter.